Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And we are here today with our continuing coverage of the Ken Paxton impeachment trial. Ken Paxton is the Attorney General of the state of Texas and has been a controversial figure in this state for many years. He has been accused of various misdeeds. He was indicted in 2015 in a securities fraud case that still has yet to go to trial, and for our purposes today is being impeached largely for official corruption, namely, in principal part, according to the documents impeaching him, he helped a guy named Mr. Paul. Mr. Paul was a real estate developer and a campaign contributor. And the idea is that Mr. Paxton used his offices in a way to benefit Mr. Paul on an individual level with corrupt intent. So, graft basically in so many words. And that is basic. And then, of course, tried to cover it up, retaliated against some whistleblowers, tried to settle against the whistleblowers with state money and so forth and so on. So far, we've heard the opening arguments from both attorneys, and we have heard two witnesses so far. We heard from the second in command at the AG's office during the relevant period in time. We've been posting some clips about him and his excitement. So he has some minor problems, and now we're hearing from, I believe it's the third in command at the Attorney General's office at the time, if I understood the sort of hierarchy correctly, or at least someone also who's in the senior leadership as well. So all that good stuff. Rob is here. Rob is here? Well, that's nice. Hello, Rob. By the way, congratulations to our good friend Rob from Law and Lumber. Rob recently became partner at a new law firm. He started his new job on Tuesday. So they're still breaking him in over there, I'm pretty sure. But that's okay. I'm sure that he'll get right up to speed. And one day soon, he'll tell us how his first day at school went. He was telling me when we were talking that he was I don't know what the right verb here would be. He was noting with amusement, I guess. He was noting with amusement, like all the new hire paperwork he had to do, because he said it had been a while since he had to do one of those things. And so that he was commenting about that, and that's fun. So I appreciate that he's there. And also, of course, good friend to our Mrs. Hogue Law, who's also here. And we want to wish Richard Hogue all the best. Of course, Richard Hogue, friend of the channel, Hogue Law. Make sure to check him out. Hogue, as many of you know, had a stroke. He's basically my age and had a stroke. Unexpected, as you might anticipate, but seems to be no worse for wear, at least as far as we can tell. And he's back streaming today, and we appreciate that he's here, and that is awesome. So all the best to them. Anyways, we are continuing our coverage of this impeachment trial. And if either of these guys wants a link, I'll be happy to drop them a link. Do you want a link or law and lumber to come in and talk about this? But yeah, so far we heard from the first assistant AG, the deputy, who was a failed nomination to the federal bench. And that came up during his testimony in a way that was particularly brutal. The person cross-examining used that piece of information at just the right time to really carve out his soul. It was brutal. And we also, he seems to be like a guy who has he almost reminds me a little bit of, what's his name? Comey. Reminds me a little bit of Comey. Like this, almost slightly holier than thou. I am the pure one. I will do what is good for the right of the world kind of thing, with this sort of slightly inflated ego. And then, doing things that are potentially in subversion of what he's supposed to do, but it's for the greater good. So he has some of those kind of vibes to him. Lifelong bureaucrat, apparently. And he said that he ran the AG's office, and apparently at one point said he controlled the AG's office. And I think he thought that on like a very literal level. He's like, who is Ken Paxton? Who is this guy with the title Attorney General? And why does he think he has the right to tell me what to do? Kind of guy. I am the first deputy assistant attorney general. Who is the attorney general, and why does he control me, or why does he think he can control me? So we definitely got some of those vibes from him. And also he may have committed crimes. And we, as we clipped out the clip, in what has to be the most obvious, brutal conflict of interest ever. And if Law and Lumber's still here, he'll like this one. So he's about to leave the Attorney General's office in like 2 days, okay? He's about to leave the Attorney General's office, and he's going to go to the FBI the next day. So he hires this guy, Sutton. To be his personal lawyer, as he's getting ready to leave the Attorney General's office and talk to the FBI. Not necessarily a bad idea, to have a lawyer when you're going to go talk to the FBI. And you're about to leave the Attorney General's office and you're about to be kicked out potentially for being a whistleblower. You might, it might be a good idea to get some legal advice. So hiring Sutton isn't necessarily the problem. The problem is the very next day, the day after he hires Sutton, while he's still at the Attorney General's office, he sets aside $50,000 of taxpayer money to hire an outside attorney for the Attorney General's office. Anyone want to take a guess as to what attorney he thought would be best attorney to fill that position and take the $50,000 in taxpayer money to work for the Attorney General's office? Anyone want to take a guess as to who he set the money aside for? Yeah, so I think there's a bit of a conflict of interest there. He apparently doesn't see it though. So, okay, yeah, it's fun and exciting. So that's where we're sitting on all of that. No, not himself. No, but his attorney that he had hired, Sutton. Yeah, not himself, but Sutton. Yeah, so he thought Sutton would be the best job to work for the person to work for the Attorney General's office. I'm like, okay. So, yeah. It seemed like there's a conflict of interest there, but he doesn't seem to see it for some reason. The Twitter link is old? Is there a problem with the Twitter link? I hope not. That looks right. Yeah, that looks right. So I don't know what the problem is. It looks right on my end. Mater came off as a giant weasel. Yeah, there are definitely some vibes along those ways, for sure. I'm just waiting for the stream to start. We could be here for a while, of course. And of course, we always have more book to entertain us if we need it. So never fret. We have plenty of stuff to cover. Is the lawyer he hired representing himself personally? No, I don't understand. No, he hired the lawyer he hired. He also was going to get the Attorney General's office to also hire. So I don't know if I didn't explain that correctly or what the confusion is. He was about to leave the Attorney General's office. He was about to leave the Attorney General's office in order to make a report to the FBI as a whistleblower for corruption. So he hired a lawyer to represent him as he's leaving the Attorney General's office, to represent him as he's going to go talk to the FBI and help him with issues relating to whistleblower protection. Meanwhile, he instructs the Attorney General's office to set aside $50,000 to hire the very same lawyer to work from inside the Attorney General's office. So, that's a pretty obvious conflict of interest. And yeah, and it gets worse from there. Conflict of interest is the good version. That's the good version. It gets worse from there. As we start to think about possible criminality, it gets worse from there. And because he was talking to other people in the Attorney General's office who appeared to be assisting him in potential agreement with him, it even gets worse from there. So you are now looking at the possibility of some combination of honest services fraud, embezzlement, self-dealing, violation of oath, and conspiracy. So it's going great. So the ethics violation is the good version. When the ethics violation is the good version, you know things are not going great. And because he was knowingly trying to do this, it's an ethics violation for him because, of course, he's also an attorney. So he's trying to induce another lawyer into an obvious conflict of interest. So there's ethics problems there, as you might anticipate. Who was paying for the lawyer? Well, he paid for the lawyer for himself, but he also had the Attorney General's office set aside $50,000 to hire the same lawyer, which would be potentially where the embezzlement comes in, because he's potentially using taxpayer funds ostensibly to hire this guy to do a job for the Attorney General's office, but in reality doing a job for him, which also, of course, is fraud, which also makes it an ongoing fraud, which also means attorney-client privilege gets destroyed. So there's lots of problems. Sound is super low. Check 1 2 1 2. Check 1 2. Nope, looks okay on my end. Hello, everyone. Welcome on Civil Law. Looks okay. Do you need me to go up from there? You need more volume than that? Am I still living in Texas? Yes, I live in Texas. I live in Austin. So low, the volume is low. Maybe it's on your end. Check 1 2 1 2. Check 1 2. It looks okay on my end visually. Yeah, it looks okay visually.
Impeachment of the Texas Senate is now in session. The Honorable Lieutenant Governor and President of the Senate, Ken Paxton, now presiding.
Well, at least they're starting on time today. That's nice.
Morning, everyone. Bailiff, please bring in the jury.
Paxton was there on the first day, but I don't think he was there yesterday.
At the bench, if that's okay.
After the prayer?
Yes,
please?
Judge.
And after the jury comes in?
Yeah, so Paxton was there the first day, but I'm not sure he's been there subsequently. Did I go to comedy school last night? I did go to comedy school last night. And again, I was somewhat frustrated by the lack of instruction at the school. So I think I need to find a different school. So I'm going to probably send them an email while the thing is on the way, basically telling them I don't think it's working out for us. This is stand-up school, and basically what they are like is like write stand-up, and they give very generic advice, but they don't really teach it. They don't really teach it. And like, here's how to actually like do it, or like, here's how beats are. They don't provide theory. And so I don't know. I was hoping for more instruction.
Good morning, members of the jury. Senator Hinojosa, I understand you're going to do the prayer this morning. Please come forward.
Good morning. Please, let's bow our heads. Lord, we come before you today acknowledging that our understanding is imperfect and limited. We ask for your guidance and direction in every aspect of our lives. As we walk down unfamiliar paths, we ask for your guidance. Open our eyes, sharpen our senses, so that we may use good judgment in every situation and decision we encounter. Help us to be patient. Help us to avoid making rash decisions and impulsive actions that may lead us astray. We understand that our choices have the power to shape our future. For that reason, we ask for your wisdom and guidance. Help us make wise decisions as we trust in you. In Jesus' name we pray. Amen.
Thank you, Senator. Please be seated.
Yeah, so it does seem like they want us to teach ourselves. And it's like they'll give you feedback on your SAT, and they'll give you like notes. But it's like, yeah, they want you to teach yourself. But I'm like, this is supposed to be a 101 class. This is supposed to be for people who have no prior experience. So I would think that, it would involve more like, instruction. So... Every legislature in this country opens their legislative session with prayer. The Supreme Court has upheld that before. So, slow your roll. Look more from prototopics? Yeah, maybe. Maybe. I don't know if David teaches or stuff, but yeah, maybe I'll look into what his stuff is. Maybe that's the way to go. In the U.S. House and Senate, they have an official chaplain who does the prayer, I think. Although I'd have to double check, but I'm pretty sure they have an official chaplain. But, yeah. Well, remember, this isn't really this is technically called a court, but it's not your average court. This is a political court. So, yeah. So, no, courts don't open with prayer, but this isn't a judicial court. This is a legislative court, which is to say it's a political court. So, yeah, it's a little different. I mean, you don't really see political courts. This is about the only context in which such a concept exists in U.S. law. But there we are. We have a political court. Literally. Very political. So, yeah. Yeah, the key thing to remember about this entire thing is it's political. If you remember it's political, you'll be a lot better off, right? Because the rules are made up and the points don't matter, right? So you'll hear like legal phrases and legal words used, but they matter only to the degree that they decide that they matter. It is one step from being an arbitrary free-for-all. Yeah, so it is a very strange creature, but here we are. They're trying to remove a political official through political means, other than elections. So, it is what it is. It is what it is. Don't think about it too hard. There is no appeal. That's correct. There is no appeal. That's correct. The Senate of Texas is the sole arbiter of this. For the purposes of this exercise, they are the Supreme Court of Texas. There is no appeal. Their word is God. So, yeah, the points are made up and the rules don't matter. Or the rules are made up and the points don't matter is probably pretty, yeah. It's pretty accurate. I mean, they have formally adopted things that they call rules, and they follow those rules, but then again, they made them up in the first place. So, I'm back with the rules don't matter. If he's found guilty, he's kicked out of office and can be disqualified from ever holding office again. So his only penalties are also political. So the process is political. The penalties are political. So there's that, I guess. They throw him out of office, or more to the point, he stays thrown out of office because in Texas, the moment that you're impeached, you are thrown out of office, unlike the federal system. So he's not in office now. So he continues to not be in office indefinitely, and he would be potentially barred from ever having office again in Texas. Maybe he could be AG somewhere else. I don't know. So the nature of the fact that the only penalties are political is what keeps this thing just. Can a state lawfully prevent a citizen from running for office? Yes. To the extent they're impeached and convicted, sure. Same in the federal system. If you're impeached and convicted, you can be disqualified from holding future office again. So sure, yes. It is a penalty that you're getting after due process. But remember, in this context, the due process is political. So it's different than your normal due process. So you're being deprived of a right, but you did get a hearing. There was a hearing and a finding and everything. It was just a political one. It's in the Constitution, okay? Don't think about it too hard. It's the law, all right? Don't try to regenerate it from first principles. It is the law. Just accept the reality and you'll all be happier. Just accept it and move on. You'll all be a lot happier. No, it would not bar him from holding federal office, no. He could run for senator or House representative or something. That'd be fine. In the federal election. And of course, like it is, and as Sandy notes, it's political all the way down, right? Because of course, if the senators don't do what their constituents want them to do, they themselves might not get reelected. So it's like political all the way down. And if the constituents get mad enough, then hypothetically a future Senate could vote to unban him from office, which happened with Andrew Jackson. Well, no, Andrew Jackson was never impeached. He was censured. And then the censure was revoked 2 years later, which I suppose is close enough for our purposes. But never mind. We're getting too deep into history. Was it Johnson, not Jackson? It was Andrew Johnson I know it was over the Bank of the U.S. Was that Johnson and not Jackson? Okay, yeah, maybe it was Johnson, and I've just confused the two. At least now at this time, right this second, I can't remember the difference. If you asked me tomorrow, I probably would know it for sure. But right now, my brain isn't working.
Members, the motion made. You asked.
But it was over the Bank of the U.S. He was censured, and then it was revoked 2 years later.
Okay.
So it was one of the Andrews.
Work product notes. All right.
Was it Jackson? God damn it! One of you guys was it?
There are no statements from this witness. We have notes.
Jackson, I was right the first time.
Mental processes and
Thanks.
everything as to what he said in summary of things and issues, but no notes and no notes have any statement.
Don't confuse uncivil. It's too early, okay? I just woke up.
That's absolutely right.
All right. Motion's denied.
Yes, Judge.
Bailiff will call the witness in.
Don't confuse uncivil. It's too early in the morning. Okay. Well, you could try to tease uncivil later when he wakes up. All right. Give uncivil a break. The judge is the lieutenant governor, whose name temporarily escapes me, but it doesn't matter, who is not an attorney himself, which
No,
also
you're
makes
still
things
on the road
fun.
from yesterday, Mr. Bangert.
Yeah, so the judge is the lieutenant governor who is
Counselor,
not
you can continue.
who is not a lawyer.
Good morning.
But it's political, so it doesn't matter.
Good morning.
Thank you. I want to go, if I can, back a little bit from where we broke up yesterday, back to the Mitty Foundation issue and your involvement in that. After the intervention that you've testified about on June the 2nd of 2020, did the Attorney General contact you personally about that issue again?
You guys are getting ads again? I thought I turned those off.
The intervention.
Let me
Yes.
double check again.
And what was the occasion? Did you attend any meeting with the Attorney General about it?
I did attend a meeting with him. We were having
They
a
just changed their
senior
ad
staff
policy, and I just got an email about
We
it
had a weekly
too.
meeting every week where all of
It
the
looks like
deputies
ads
would
are turned
gather
off on my
in the
end.
main conference room, and
So maybe I just can't turn off all the
ads.
ads. Maybe I can just maybe I can just push a button
Can you
that
give
will
us
give
a
you
time?
even more ads.
The meetings happen.
So
in
I
the
have
morning.
a button I can push
roughly
that says
mid-morning.
insert ads.
It was.
So I guess your
I believe
choices are
after the
between
intervention,
some ads
it
and
was
even more
prior
ads.
To,
So I guess you'll
my
have to
being
have some
removed from the
ads.
case by First Assistant Mateer.
All right. So
I regret the
what did he
inconvenience.
say? Just if you could repeat what he said to you and asked for.
He came to me in the meeting. The meeting had already started. He approached me and said, "I need you to come with me to lunch."
And did he say any further? Who was the lunch going to be with?
Nate Paul.
What did he say to you as to why he wanted you to go to lunch with Nate Paul?
He didn't say specifically at that time. He just said we needed to go and have lunch with Nate Paul.
Did he indicate why he wanted you to go to lunch with Nate Paul?
It became clear subsequent to that what the meeting was about, yes.
What was your position at that time that you had stated to him before the intervention and even at the time of the intervention as to whether you were opposed or unopposed to it?
I was very uncomfortable with the intervention. We had discussed it. There were ongoing conversations after the intervention that made me even more uncomfortable with our position in that case. And I had communicated to him what I believe were the pros and cons, and we were very heavy on the con side.
So where did you go to lunch?
I believe it was...
Samsodi says, can they ask leading questions? No.
And,
Has that in any way
went to
stopped
the
him?
lunch with
Also
you?
no.
Well, it was, we had to go through some gymnastics to even make the lunch happen. It was with the Attorney General and Drew Wicker. From the
There was some
Attorney
really
General's
bad
office.
leading questions
Yeah,
before
how many
too.
weeks
It was like
after the
leading
intervention
5 different
and
ways.
After you had expressed your opposition.
So these are
how
very
many
mild
weeks
leading
after that
questions
would
by
this
comparison.
luncheon have been?
It would have been 1 to 2 weeks after is my best guess. I can't tell you precisely, but it was sometime in mid-June. It was very warm.
Did he ever ask you to go to lunch with anybody that represented the Mitty Foundation?
No.
Did he ever ask you to go to lunch with the lawyers representing the Mitty Foundation?
No.
In the entire litigation that had been going on for several years, did he ever ask you to meet with anybody other than Nate Paul, one of the parties to the litigation?
In connection with that case, no.
All right. Now, when you arrived at lunch, can you describe the lunch for us, please?
The Attorney General drove us over to Nate Paul's office, which is not far from our office, and left his car there. And as I recall, we piled into Nate Paul's car, and then he drove to Polvo's.
As a lawyer, what was your reaction to being asked? Did you consider it an ask or a directive? Let me ask you that first.
Objection, relevance.
Overruled.
I've simply asked you, I've given him a choice. I'm not telling
Yeah,
which is
overruled. You can ask the question.
Thank you.
The objection wasn't leading. The objection was
not
relevance.
a request to which I could say no for reasons that I can explain.
Please.
Yeah.
The reasons why were Jeff Mateer and I discussed briefly the request that I go to lunch with Nate Paul. And we very quickly determined that it would be
Objection to
inappropriate.
hearsay. He's talking about a conversation with Jeff Mateer.
No, he didn't say what he said. It's not hearsay.
Let me
Overruled.
re-ask it a certain way if I can. Thank you,
Please
Your Honor.
sustain that and re-ask.
Thank you very much. All right. Let's go back now to apparently more happened on their initial request. Let's go back to when, at the meeting, he wanted you to go to lunch with Nate Paul. What was your initial reaction when he asked you that?
I was concerned that I was being asked to meet with the principal of a party in a lawsuit to which we had intervened.
And so without going into what Mr. Mateer and you said, who did you go to talk to?
I visited with the Attorney General, and I explained to him that there were ethical concerns because as counsel for the state of Texas, I would be meeting with a represented party in a lawsuit to which the state of Texas had intervened.
Yeah.
So what did you ask to him if you could do, and what did you do?
Ethically dubious
I
at
explained
best.
to him
Objection to
that
hearsay.
What? It's not. It's a conversation with the Attorney General.
It's
Overruled.
I explained to the Attorney General that the only way that we could properly make this work under the rules of ethics is if there was a waiver from Nate Paul's counsel allowing me to speak directly with a represented party. My assumption was that that would terminate the request and we could go back to the meeting.
So was that the course that you took?
Yeah, it's in the rules of ethics. A
privately
lawyer
consulted
can't
with
meet
Mr.
with
Mateer?
a
All right.
a lawyer can't
And
meet
then
with
when
the
you saw
client
the Attorney General
no, let me try
what
that
did he
again.
do?
A lawyer can't
He
meet
went
with
back
a
to his
represented
office
party.
for a short amount of time, and
It's a big
emerged
no-no.
with a document that
The parties
purported to
can
be a
talk to
written
each
waiver
other.
from Nate
The
Paul's
lawyers can
counsel,
talk to each other.
giving me permission
But the
to
lawyers can't
meet
talk
with
to
Nate
opposing
Paul
party
without his lawyers.
without their lawyer present.
Mr. Banger, how long did it take the Attorney General of the state of Texas to go into his office, contact the counsel for Nate Paul, and get a document prepared that waived any objection that lawyer would have to you talking directly to Mr. Paul?
Objection, speculation. This witness doesn't know what Mr. Paxton did in his office.
The question was how long it took.
Overruled.
Thank you.
Yeah.
Excuse me. Thank you.
No more than 15 minutes.
And what was the document he brought it back to you in 15 minutes?
My recollection is it was a document that had been faxed or emailed to him. It was not something that I believe he had prepared. The appearance of it was not something that he would have prepared. But it was a document that had been prepared by one of Nate Paul's lawyers, waiving any conflicts that might arise from me as counsel for the state of Texas, meeting with a represented party.
All right. Well, after that process and all, did you feel free to decline the lunch meeting, or what was your reaction? What did you do?
Well, I told Mr. Mateer that he had gotten a waiver, and I was pretty much straight out of luck at that point. I had to go.
Now, when you went to Mr. Paul's office, where was his office, by the way?
It was in downtown Austin, south of here, but I don't recall specifically the location.
And when you went, I mean, you guys actually went and got in his office and got in his car and went in his car?
We went and parked in his parking lot and got in his car.
What kind of car does the AG
Describe the
drive?
lunch for us. Where did you?
I wonder what kind of car.
A public area or a private area or what?
We went to Polvo's. I recall the layout of the restaurant. It was Polvo's downtown. We went into the restaurant. If I recall correctly, Nate Paul wanted to sit outside, even though it was warm. So we sat out on the porch. It was very uncrowded. There weren't many people there. And we sat down for lunch.
And how did the conversation go? Did Mr. Paxton introduce the subject, or did you introduce it, or did somebody else do it?
Polvo's is
Not
204
entirely sure
South
why
First
I was
Street.
there, but it became very clear.
Have I been
Nate
there?
Paul,
I think I have.
in the moment we sat down,
Objection, non-responsive.
I'll go.
It's a little Mexican restaurant.
Thank you, Judge. If it's okay, I'll
Sustained
withdraw.
and continue.
Thank you very much.
Nothing fancy.
Who was the first person to speak, if you recall?
Nate Paul did almost all of the talking.
Did the Attorney General do any kind of introduction or anything? What was his role in this conversation?
It was nothing more than, Ryan, this is Nate Paul, and there are some things he'd like you to hear. That was effectively the upshot of it.
There was some thing, he said what?
I'm paraphrasing now, but it was to the effect of, this is Nate Paul, and he has some things to share with you.
So then what did Mr. Paul do?
He proceeded to lay out his theory of the case.
Objection, hearsay. He's talking about a statement by Nate Paul.
Sustained.
Did the Attorney General during this entire conversation reject anything that Mr. Paul was saying?
No.
Did the Attorney General of the state of Texas do anything to show that he did not agree with the things that Mr. Paul was saying?
No.
So once again, this conversation with Mr. Paul that was had in the presence of the Attorney General, what did Mr. Paul say?
Objection, hearsay.
It is hearsay.
The reason for this is all in the presence of the party, the Attorney General, and his silence or his statements are acquiescence in adopting the statements of Mr. Paul. That's why I don't believe that it is subject to the hearsay exception.
Judge, permission to respond?
Respond.
There is no evidence that this witness can talk about that Mr. Paxton has adopted any statements made by Mr. Paul during that conversation. And because of that, it is not a statement that is adopted by a party opponent, and for that reason, it's still hearsay. Any statement by Nate Paul is hearsay at that meeting.
I think he's right. Let's see what legal counsel says.
Continue.
Overruled? Okay.
What did he say?
Mr. Paul laid out his theory of grievances against the Mitty Foundation. He described to me how unfair it was that a charity that was a limited investor would be able to assume control over assets that were owned by World Class. He was very vehemently opposed to the receivership. He, as I recall, was more or less railing on the way that Ray Chester and the counsel for Mitty Foundation had handled the case, and more or less went through a number of different complaints that had been raised in a memorandum that had been provided to me by his sister, Sheena Paul.
I think it'll be coming clear in later testimony from others, but Sheena Paul is a lawyer, is that correct?
Yes.
And she's the sister of Mr. Nate Paul, is
That's
that correct?
correct.
But your familiarity with the case, had she been actively involved in the litigation on behalf of her brother?
I don't know how actively involved she was. My impression was she was involved as general in-house counsel for World Class, yes.
All right, fair enough. How long did this description of his complaints and his position with by Mr. Paul, how long did that last?
Oh, the lunch lasted for a good 30, 35 minutes, if not 40. Somewhere in that range.
Did you folks have food?
We did order food. I don't think I ate very much.
Did the Attorney General during this meeting ever reject?
Did you guys have drinks?
Or try to modify or ask questions?
Gotta get a margarita, man.
During the time that Mr. Paul was pleading his case to you?
He did not, no.
How did the luncheon end?
Mr. Paul completed his exposition, and that was a signal for the lunch to end.
Did you ask any questions?
I may have asked a few questions, I don't recall, but it very much had the feeling that I had been summoned to a lunch.
Objection, non-responsive.
Excuse me. I don't know whether it was or not. I don't know what the answer was.
Sustain the objection, rephrase, please.
Thank you. What was your impression about that, what that whole meeting was about?
The strong impression that I had developed was I had been summoned to that lunch by Nate Paul to hear out his grievances and to convince me to get on board with the Mitty Foundation intervention program.
So how did it, once it ended, what did y'all do?
We parted ways, drove back, got back in the Attorney General's car, and came back to the office.
Did the Attorney General say anything to you about the case after y'all left Mr. Paul at his office?
Very little.
Did y'all just sort of sit there silently?
As I recall, it was a very quiet ride back, yes.
And was Mr. Wicker present for this whole conversation?
He was, yes.
Did you talk to Mr. Wicker about that after you came back?
I did.
All right. And did you yourself express yourself as to what you thought about the lunch?
Yes, I did.
What'd you say?
Objection, hearsay.
This man is here. It's not hearsay. A statement by the witness, Your Honor, is not.
Overruled.
Thank you. What did you say?
I told him, Drew, that was one of the craziest things I've ever seen.
His response?
Objection, hearsay.
Okay, thank you.
Sustained.
All right. Thank you, Thank you, Your Honor. We'll move on. Now, let me, how old were you at that time of that conversation?
How old was I?
How old were you in the summer of 2020?
I was 42 or 43. I'm trying to do the math in my head. 42, I believe.
How long had you been a lawyer?
I had been a lawyer since, for about 15. Well, I think I was 43 now that you mention it, because I'm doing the math. I was 43. And I had been a lawyer for the better part of 15 years at least.
Had you ever, in 15 years as a lawyer, experienced anything like that?
Objection to relevance and an improper opinion, Judge.
I'm just asking him if he's experienced, he'd ever had anything similar as a lawyer.
Overruled. Continue.
Go ahead.
It was, as we say in the Latin, sui generis. It was one of a kind.
Nice.
I've never seen anything like it.
Sui generis.
Now, I can, if...
Self-generating. It's a one-off. Nice.
There is one fact I want to try to...
Very good. Very fancy, sir.
Subject. But at this time that y'all are spending this time dealing with Mr. Paul's issues, what all is going on in the Attorney General's office as far as real work that you guys and women were responsible for doing? What's happening on the landscape in the state of Texas and in the Attorney General's office that y'all wanted to be working on?
We were working around the clock on COVID-related issues, and we were also preparing a major multi-state lawsuit against Google.
And is that Google lawsuit still pending?
As far as I know, it is.
But has it since been given to an outside law firm?
Yes.
At the time you were there, was it being handled in-house or by an outside law firm?
In-house.
Right. Did it remain being handled inside the firm, inside the agency, until after all of you resigned or were fired?
Objection, this witness doesn't have personal knowledge of that.
Let me put it this way. Of the people that left on the top floor that were all terminated ultimately, the 8, what people have called colloquially the 8 whistleblowers, was Google ultimately farmed out to a private law firm after all of y'all were gone?
Objection, hearsay. Objection, lack of personal knowledge.
The hearsay is
Overruled.
Thank you.
I believe more than one law firm, yes.
Pardon me?
I believe more than one, yes. Outside firms.
Now, the microphone, I can't tell, I don't know whether it's being picked up behind me, so if you could just, maybe, if it's louder to me, then maybe it'll be louder back there, okay? In addition to Google, were there other major pieces of litigation going on that you were responsible for?
Yes, there were.
What?
The Special Litigation Unit was very busy handling a number of election-related lawsuits.
All right. And were there other areas? What was y'all's experience or involvement at that time in trying to cope with COVID-related legal issues?
We had a section called the Disaster Counsel Advice section under the General Counsel that was handling a flood of requests from local officials as to how to handle COVID.
Well, when the Attorney General kept raising Nate Paul issues of the ones that we've gone through so far and later in the future, do you have any idea how much time or resources that were devoted to dealing with Nate Paul instead of real concerns?
We were devoting far more resources to Nate Paul than we ever should have, given the importance of those issues.
Can you put any kind of quantifying amount on it as you sit there?
Well, certainly the opinion that we discussed yesterday consumed the better part of 3 days of my time that could have been spent working on other matters. And of course, the Mitty Foundation consumed a lot more time than that.
Now, I want to ask you if I can, and then of course we haven't gotten to whatever time was expended on the hiring of somebody purportedly being a special prosecutor. In other words, the hiring of an outside counsel. We haven't even discussed that.
Objection to attorney testifying.
Excuse me, let me finish my question, please.
Judge, my objection is to the call of his question.
Counsel, let him finish.
Yes, Judge.
And then you can object. Mr. Hardin, you can finish your question.
Thank you. Do you have any idea how much more time and resources were devoted to once you discovered this issue of an outside counsel being considered and then being done?
It was many, many hours. We spent days dealing with the fallout of that. And that was all of us together. So 7, 8 of us at least, plus a few support staff. So it would be hundreds of man hours.
All right, now, Mr. Bangert, I want to go to, you mentioned what some of us colloquially have called the midnight opinion. Can you tell us, without not necessarily a long legal description, is there a section in the government code that deals with these opinions?
There is a very distinct section in the government code that deals with our authority to issue opinions, yes.
All right. So when we talk about opinions, very briefly, that come out of the Attorney General's office, how many types of opinions would you say there are involved?
There are there are a handful of types of opinions involved. The first would be an opinion issued pursuant to our government code 402 authority to issue opinions to individuals who are authorized requesters.
All right, let me stop there. So Section 402 of the government code authorizes you to produce opinions in response to whom?
Very specific individuals. There's a list in the code. Chairmen of legislative committees are one. Certain statewide officials. There are a handful, I believe, of local government officials who would be authorized, but it's a very distinct list, and that list cannot be waived.
And is there any distinction in the government code between an informal and a formal opinion?
No.
Do you recall whether or not in the opinion that y'all wrote at the Attorney General's request, do you recall any language at the end of it that talked about it was an informal opinion guidance? Can I put up, do we have an exhibit number for, can I step over to just get an exhibit?
Why don't you let him answer the question first and then put up the exhibit would be a better way of doing this. Like, stepped on your own question. So, basically, I think what they're trying to prove right now is they're trying to prove, because this Attorney General memo apparently says at the end, effectively, this is not an opinion of the Attorney General. And so I think what they're trying to demonstrate is, notwithstanding that language, yes, it really is. Which, maybe. I mean, just because you say this is not X doesn't mean it's not X, right? You can't magically just say...
Stacey, can I ask you to put...
You can't magically say this is not copyright infringement, and so it's not, right? So I think what they're trying to demonstrate is, despite the fact that the memo itself says this is not an opinion, it really is an opinion.
Can we go to the end of that opinion, please?
All right. Let's give that a shot.
First of all, do you recognize...
Counselor, has this already on the list of admitted evidence?
This has already been admitted.
It has been. Okay.
Yes, this is one that's agreed. Thank you, Your Honor. Do you recognize this exhibit?
I do.
And what is it?
The first page, this is the opinion that we worked on and issued August 1st in response to the Attorney General's request concerning foreclosures.
All right, and this is the opinion you've talked about earlier that was completed at about...
I believe the lady sitting next to him is actually a justice of the Supreme Court.
Now, if you would...
So she's more than just a lawyer. I'm pretty sure she's a justice.
End of the opinion?
So, not that she has anything better to do, I'm sure.
Now, could you explain to us...
You got to love that. You're a justice of the Supreme Court and you've been turned into someone else's legal advisor.
Distinction in the code between informal...
That's a rough demotion.
Judge, I'd object that is an improper legal conclusion by this witness.
What? I'm
Overruled.
Sorry. Thank you. This opinion that you drafted, and this is actually an opinion that you signed, correct?
Yes.
And was this division and this matter under your supervision and control?
It had been.
All right. Before you became the deputy first assistant, is that what you mean?
Yes.
Okay. All right. So the language says, I'm trying to stay with the microphone to be able to read. It says, please note.
She wasn't on Supreme Court. She was on Fifth Circuit. Thank you.
Under Section 402.
I stand corrected. Thank you, Admiral.
442.
I appreciate it.
Texas Government Code. Rather, it is intended only to convey informal legal guidance. Explain to me what the significance of that and is that inconsistent with your previous testimony?
No, it is not.
All right, explain, please.
Well, I would analogize this to the practice in Texas courts of issuing published and unpublished opinions. We have an obligation under 402.045, which is part of the opinions authority, only to issue opinions to individuals if they are authorized requesters. You cannot simply issue opinions as the Attorney General's office to any individual who asks, because we are not a private law firm. We serve the interest of the state.
So if I walk in off the street or have something in my business or so that I really want an opinion for, am I entitled to ask the Attorney General's office to give me an opinion, just to give me the legal advice?
No, not unless you're one of the listed statutory requesters.
Is a legislator one of those people that is authorized to ask?
Chairman, yes.
All right. And it has to be a chairman of a committee?
Yes.
And in this case, as we've talked about yesterday, that's what happened, correct?
Yes, I believe Senator Hughes at this time was chair of the State Affairs Committee and possibly one other.
All right. Now, was there a time in the history of the Attorney General's office in which the office did issue informal opinions?
My recollection was that, yes, there was a time when we would post opinions on our website that were informal in nature.
All right. And are you aware that your website, their website now, the Attorney General's website now, indicates that stopped in 1979? Is that anywhere consistent with your? So explain to me why you put this language in here then that said it's not a formal Attorney General opinion. It is intended only to convey informal legal guidance. Explain why that's okay, or why you put it there either.
Yes. The normal opinions process involves going through the opinion committee. It's a very rigorous process of drafting, review, approval. It goes up through a number of different layers of review. This did not follow that normal process. It did not go out for briefing for third parties to evaluate and consider whether they wanted to brief on this. So none of those procedural aspects were associated with this opinion, nor did it receive what we call a KP number, which is a formal opinion assignment number for publication on the website and ultimately publication on Westlaw.
Well, as far as the statute is concerned, is there a distinction by what you did on this opinion that night? Any different? Is that opinion and its consequences any different than in terms of its effects on the outside world?
Objection.
Excuse me, let me finish my question.
I don't know if I buy this legal analysis or not.
Start over. Is there any difference on the impact on the outside world of what you did here in this particular opinion and what an opinion
I'm thinking, by the way,
that went through
my brain is not working at 100%. I'm thinking.
Months or so.
No, all of our opinions have persuasive value.
Improper legal opinion.
Overruled. Continue.
Why did you say that then?
This signaled to the reader that this opinion had not gone through the formal, rigorous process of review by the opinion committee. It had not gone out for briefing. It had not gone through the normal process that can take up to 180 days of time. And it was also not going to be receiving a KP number. And I don't believe this is published on Westlaw. I haven't checked, but I would be surprised if it were.
So why did the two of you decide to do it this way, to put that sentence in there? Would you ordinarily have put that sentence in an opinion where, say, another chairman of another committee asked for it, et cetera? Would you have ordinarily put this sentence in there?
Yeah, so here's a couple things I'm thinking in my head as I'm trying to analyze this.
Process.
So
there were other opinions.
This reminds me a little bit of the discussions we were having, for example, with Trump as it relates to his ability to classify or declassify things.
And they did not go through the formal process.
There is a normal process that normally exists that they normally follow. But just because it is the process they normally follow doesn't
This
mean
signals
that
it did not
the president,
receive the
for that
rigorous
example,
review
or the AG for this
that an
example,
opinion of our office
are
normally
bound to that process.
So if lawyers in court
because
are contesting
the process that he's
having
referring
a controversial
to
issue,
is, to
and
the best of my
their
knowledge, not
side
in the code itself,
to introduce this,
nor is it in any
that
sort of
sort of a
formal
signal to
regulation.
anybody
It is
about
just
the process
internal
that they might have an argument
policies,
to the
internal
judge?
to the AG's
Wait a minute,
office.
this is-
In the same way that, for example,
there's no such
the
thing- may not be
classification
such a thing as an
memo
informal opinion,
that they
Judge.
normally follow is an
This
executive
opinion did
order.
not go through
It's
the
created
rigorous
by the
process
executive,
that
and the
normal
executive
opinion.
can ignore it.
Would that
Right,
argument
because
be
it's not
available to
law. Or it kind of is law, but it's only it's law that the executive can ignore because they created it in the first place.
This had not gone through the formal process.
So that's the first thing.
noticed
So
your eyebrows
he seems to be
go up when you're
confusing the idea
mean that
that
you
just
had thought about it before I
because
just asked this?
they didn't follow the
no,
process
this
means
is-
that it's inherently illegitimate,
This is something that we were
which
dealing
I
with
don't
in mass.
agree with.
Section non-responsive.
Right? The
There's no
attorney,
question asked.
the statutory authority exists for the
Having
AG
these kind of- excuse me.
to
Were you having
give
these kind of questions all
a
the time? Or not all the time.
memorandum,
Put it another way. Were you
or an opinion,
frequently having
rather.
to deal with this kind of issue?
and the AG can
this
kind of do
time-
whatever he likes.
This specific moment.
And if he wants to not
we were
follow the
dealing with
process,
an
he doesn't have to
unusual
because it's not
influx
created
of
by law.
Requests for
So that's number one.
And was there a process
Number
in
two,
which you could provide?
Just because
other
the Attorney
ways
General
that you
has
could provide
authority
but
to
rather than
issue
just this,
formal
but you
opinions
do things in another way,
under a
like
particular
press releases
statutory
and things
authority
like that.
does not necessarily
We're
imply
not
that he
providing
doesn't
legal
have
advice to an
authority
individual.
to
We can send out press statements.
just
we can
write a
send out,
memorandum
bulletins
because he
or
wants to,
announcements.
right?
I don't
If you
see
want,
anything that would preclude
the
us from
legislature,
doing
in
this.
other
The
words,
code
created a mechanism
405 is very
for
clear
an
that if we're
official
providing advice to
opinion
an individual
from the Attorney General.
then that
And because
individual
it's an
must be an
official opinion
authorized
from the Attorney
requester
General,
for the purpose
that
of ensuring
official
that
opinion
the interests of
has
the state
legal weight
are being represented
to
by
it.
that request.
At least as far as it
Are you
relates
aware, one way or the
to
other,
governmental
whether
actors
opinions like this
within
might
Texas.
be used by litigants in private
Right?
litigation?
That
I
opinion
assume they are because that's what
is-
they are posted
Objection,
on Westlaw.
speculation.
has official legal weight.
Not there for the litigants.
But
Overruled.
that doesn't necessarily, just because the Attorney General has the power to issue something that has official legal weight doesn't necessarily mean that he doesn't have authority to issue something that doesn't have legal
If the
weight.
court
Like
sustains it, he can ask
musings,
for other things. But this
because
constant
he still has
interrupting
freedom of
the witness
speech,
in the
right?
middle of the statement or the
So can the Attorney General just,
Is undue
because he wants to, and woke up that day, issue an opinion that
To
says,
object if the witness is testifying.
Whatever.
Things that shouldn't be admissible.
as long as he makes it clear it's not an
Wait for him
official
to say
memorandum,
hearsay before I make that
because it's just
objection.
his random
So I would
musings?
request to
I would
wait
think
till
so.
Mr. Hardin finishes his question
So-
and then lodge my objection.
Those are my twin thoughts
If you're
on
talking
this.
over each other, the court reporters can't
Those are my twin
report
thoughts.
accurately what either
So
of you are saying.
I would expect,
Jurors can't
although I
hear
might be wrong on
what
this,
you're
I would
saying.
expect the defense to
I
be
understand, Counselor.
something along the lines of,
Not talk over each other.
Yes, Judge.
the Attorney General has authority
Now,
under the First Amendment
quickly, and we're about through with this issue.
to
but
just
I want to know
say
if
shit
there are other ways that
that
y'all
doesn't
chose
have
to
legal
enforce
weight to it.
For instance, if mayors
Because it only has
what was
legal
your
weight to it
experience
if it's
during this
issued under
period
the
of time, if
specific
mayors of
statutory
cities
authority.
or local government
So we'll see
spokespersons
whether or not I'm right in
were contacting you
forecasting
for
that
legal
defense,
guidance.
because that's
How did
what
you
comes to my
approach those
mind.
kind of issues in dealing with COVID.
Yes.
That may not necessarily be the entire
legislature
defense.
had granted our office
but I
authority
would
under
expect it to be
Section
part of it.
418 to respond
That this
to
was-
requests for legal advice.
That
from
that
certain
line was
local
specifically there
officials, mayors are
specifically
one of them,
because the AG
for issues
was not
related
intending to invoke
a
this
declared
section
disaster in their
and was just
jurisdiction.
doing it because
That
he wanted to,
Code
because he
was
can,
passed, my understanding, in response to
because First
hurricane
Amendment.
disaster.
Something along those lines.
No
We'll see how
one
close I am when
anticipated
we get there.
every single county in the state of Texas being placed under a simultaneous disaster declaration in response to COVID, but so it was. So we effectively became available to officials in 254 counties throughout the state of Texas under 418.
Do you have any knowledge one way or the other through discussions and activities in the Attorney General's office as to whether or not the Attorney General had indicated he was aware of other possible ways to address someone's concern about a gathering other than Section 402?
Unless there was an authorized requester under 418, no.
All right, thank you. Now, at the end of the day, once this process was completed, was there any distinction in however it would be considered by others in this opinion and the opinion that went through the very rigorous 6 months of research and consultation?
The effect is the same. They have persuasive value based on the solidness of the reasoning and based on the fact that it's issued by the Attorney General's office. It's the persuasive value of the opinion that follows it.
Thank you. Now, when we can, I want to go to one final question. Is an opinion under this Section 402 that you issued, is it considered just as authoritative, though, in terms of its results, as an opinion that goes through the rigorous examination that you described?
There's no reason it would not.
Okay. Now, would it have the same ability and the same impact if one wanted to seek to use it in litigation?
Again, the reader would evaluate it for its persuasive value, just like a formal opinion.
All right. Now, I want to move, if I may, sir, to what happens starting in your experience. When did you become, with the outside counsel, when did you become aware that the lieutenant governor wanted to appoint outside counsel?
Senator.
Objection.
Counselor, I almost called you senator, so we're even.
You know, I've done it again.
Yeah. I'm going to be forced to hold you in contempt soon, Harold. Just kidding. Just kidding.
I'm just thankful I didn't put a name to it.
So am I. So go ahead.
All right. Let me start again. When did you first become aware that the Attorney General was interested in and concerned and wanted an outside lawyer hired to deal with an investigation of Mr. Paul's complaints?
Action leading.
When did you first become aware? Is not leading. Yeah, that's not leading. When did you first?
It would have
become
been
aware
sometime in August or September that I learned.
What, when, where, why, baby?
Outside counsel request.
All right, there we have seen one that talks about the matrix that such a request would have to go through. Were you aware that Mr. Vassar had drafted a contract at the request of the Attorney General's office before? And if so, when did you become aware of that?
I was aware of that, yes.
And had you taken a position about whether or not to hire an outside counsel?
With the Attorney General,
And
no.
your microphone.
I had not, but I obviously in conversations, I should say obviously, in conversations with other senior staff, we were very much in agreement. This is
Objection
not
to
a proper.
hearsay. Objection to hearsay.
He hasn't. See, that's the problem with doing it. He did not talk about what they said. He did not talk about any statement. And this interruption of the question keeps it from being clear as to what he was going to say. That's my concern.
Overruled.
Thank you. So, and the question was your position.
Improper.
All right. And do you recall when's the first time you told the Attorney General that yourself?
I did not have occasion to speak with him about this as it was outside my line of authority.
All right. So if your opposition that you thought you were opposed to it, would that have been communicated to others rather than the Attorney General?
Objection.
Yes.
Hearsay.
I'm sorry, what was the answer?
I'm objecting, and I would ask for a ruling, Judge.
Counselor, you're talking over him, and I can't even distinguish what you're objecting to, what he said or what he said. So let's start over on that question.
Sure. Thank you, Judge. Were your conversations, without going into what they were, about this subject with other people rather than the Attorney General?
Yes.
Objection. Okay.
Overruled.
Yes.
Thank you. Now, at the end of when did this, from your perspective, when did this issue boil over?
When you say boil over, could you be more specific?
Yeah, if you could, again, it sounded to me like you moved away from the microphone a little bit.
Mr. Banger, you could speak a little louder, I think.
Yeah,
Speak up a little bit
Are we
more.
fashion critiquing his, or fashion critiquing
I didn't know that
his
moved.
suits
Okay.
with the pink tie on the blue?
Probably not.
So,
I think I like it.
don't mess with the base of it very much, or we can
It's
both
it's sort of like
when I used
springtime
the phrase,
Southern, but you know, I think I kind of
mean
like
by
it.
question. What I mean is, when did this become an issue of concern to more than just one person in the criminal justice division that you became aware of? What time frame is all I'm asking you?
Increasingly through August and into September, it became an issue of very urgent concern for me, as well as for others on the senior leadership team.
All right. Now, tell me what it was, in fact, when did
It's
this
fall?
issue first surface, and what matter did it surface
Maybe.
that gave you concern?
Maybe. Is it like it's an
When
after
you say
Labor
the
Day
matter, it
thing?
would
Is that
be
what we're doing?
with regards to Nate Paul?
Is that what we're doing? It's after Labor Day, so it's no longer
Concerns have
appropriate?
been growing
Okay, well, that's a perspective, I
exponentially
guess.
over the 9 to 10 month period that we were dealing with matters related to Nate Paul. It began when the opinion when I was asked to intervene and work with the open records requests. It was uncharacteristic. It continued and was heightened when I was asked to work on the Mitty Foundation project.
All I know is I see a disturbing
exceptionally
lack of seersucker.
After the opinion,
And I
was
guess
issued
that
because
that's
felt we were
the
gonna
difference
break in
between
trust
Texas
at
Southern
that point.
and South Carolina Southern.
And of course,
because the fact
when
that there
we
isn't
learned
one
that,
seersucker
when I
to be
became aware
found
that the Attorney General
is a
now
massive
pressing for
disappointment in my Southerner's heart.
criminal
That is going to be the
investigation
change
of
I'm going to bring to
individuals in the
Texas.
community
I'm bringing
based on
seersucker
allegations
personally
that all of
to the
us
great state of
believed, and I certainly
Texas.
believed, were frivolous at best.
It's going to be my legacy.
Concerned.
Now, without going into what other people told you at the time in a specific conversation, did you become aware of generally the subject area or so that the Attorney General was seeking to hide outside counsel to investigate?
Yes, it involved the law enforcement action concerning Nate Paul and his properties. He was concerned that again, this was his same mantra over and over again.
When you say he, are you talking about the Attorney General?
Well, Nate Paul, and in connection with the Attorney General, arguing that law enforcement had been wronging Nate Paul, had been oppressing Nate Paul, and had been treating him unlawfully. There was no evidence that I had seen whatsoever to substantiate any of that.
Judge, I would object to that. It's an improper opinion. It's speculation, and this witness doesn't have personal knowledge of Nate Paul's opinions or feelings at that time.
He's expressing his opinion of what gave him concern on an evolutionary, evolving way, Your Honor.
Counselor, I think he's expressing his opinion, so overrule.
Yes, Judge.
Now, when exactly did you start getting involved in...
Someone asked, is there a resolution setting from the vid of the hearing? No.
We were discussing
There
it
is
actively
not.
throughout the month
This
of
is straight
September.
from the Texas
All right. Now,
Senate thing, and that is all the
were you
resolution that they are
aware one way or
giving me.
the other that Mr. Penley was refusing to sign the contract that had been drafted by Mr. Vassar?
Is it not
to retain
very
Mr.
good?
Kamek?
Yes.
Do we need a different source? Do we need to like go to YouTube and hope that they have a better
Had you
better
seen
thing?
the contract that was proposed?
I do not recall, although I had certainly discussed it with others.
Did you, in fact, take any position in these meetings, you yourself, of senior staff, on the advisability of hiring
good enough
Mr.
for
Kamek
government
to
work.
go investigate multiple public law enforcement persons? Did you?
Yes.
And what would you say? What was your position?
Objection, hearsay.
It is not hearsay. There is no hearsay for the witness on the
Overruled.
stand.
Counselor, he's asking him for his opinion.
Okay.
What was your position?
I mean, it looks to me
basis
like
or
on YouTube they're
justification
using
for
the
it. It would
same
not serve the
feed
public
source.
And if you had to describe...
Yeah, they're using the exact same
opinion
feed
of-
I'm using, so I'm not sure it gets any
How
better
many
than this,
of you
guys.
were
This is all
involved
we've
in this
got.
issue at the senior level?
That's as many lines of resolution as you're going to get.
David Maxwell, Mark Penley. I'm Ryan Vassar, obviously. Lacey Mays, because she was working with Mr. Vassar, and Blake Brickman as policy would have.
We got 5,400 people watching the impeachment on WFAA.
Whistleblowers, have you not?
Feel free to go to their chat and tell them that Uncivil Law is broadcasting and they should go over there instead if you want.
It was also concerned.
Is brigading legal on YouTube? Probably not.
Focus was primarily
maybe
civil.
ignore that.
All right. Now, I don't think I asked, maybe if I did, I want to be clear. Have you sued in this case?
I have not sued the Attorney General, no.
And so as we look and listen to people in this testimony, Mr. Mateer and you both, neither one of you have sued or sought any damages or compensation. Is that correct?
I have not sued, and I am aware that Mr. Mateer has not either.
All right. Now, when how did this thing come to a crescendo, if it did? When you talk about the first week in September, what events were you aware of that affected what happened at the end of September?
I was in Atlanta, Georgia, at a conference with Mr. Mateer. We were about to join a significant telephone call with our multi-state partners to discuss the Google litigation that was planned. The call was set to begin. It was a very important call for coalition building purposes. Mr. Mateer received a telephone call. It was from the Attorney General, and I was witness to Mr. Mateer's side of the call. The call had nothing to do with Google. It was all about Nate Paul.
And at that time, how big an issue and a matter and piece of litigation was the Google case in the Attorney General's office?
It was consuming substantial resources and was a major initiative of the Attorney General's office, and it was, yes.
Did you two inform the Attorney General you were about to go into an important meeting on Google?
Yes.
What did you say?
Mr. Mateer was the one communicating directly with the Attorney General, but something to the effect of, do we have to do this now? Because we're about to have this Google conversation.
Thank you for the 600 of you who are here, by the way.
I could not hear his
I appreciate every one of you who are here.
Continued for
Hope you're enjoying the stream. I am.
Assume his response was yes, we have to.
His objection is to you assuming, and I agree with that. Don't assume what happened, but as a result, even though the Attorney General was told that you were about to be involved in a meeting on a very major piece of civil litigation, did he terminate the call to talk later?
No, it continued for some time.
Objection to speculation. He couldn't hear Ken Paxton on the phone.
Counselor, he asked if he terminated the call.
Yeah.
Continue.
Thank you.
Overruled.
Thank you. Now, this conversation that lasted, were you part of it in terms of being able to respond and hear the Attorney General?
I could not hear the Attorney General, nor could I respond to him.
Could you hear the conversation in response by Mr. Mateer?
Yes.
And the conversation lasted again about how long?
We went right up to the bell. We were almost late for the Google call. It probably took about 10 minutes.
Your Honor, I would urge that this conversation, which was happening between the two of them, is actually not hearsay in the sense the content of what the Attorney General was saying, or what Mr. Mateer was saying, rather, not offered for the truth of the matter of what he was saying about Nate Paul, but only
to his
that's what he
response.
was telling these folks.
Yeah.
So
you need it for the context,
like to
for it to make sense.
As to what he was
So
having with
that
Mr.
will work.
Mateer as they were talking.
Hold one
with the
second,
judge.
Counselor.
Sure.
Yeah, because like his part of the conversation is obviously admissible, but it doesn't make any sense to only admit his part of the conversation because like what is he responding to? So then you're not offering the other part of the conversation necessarily for the truth, but how he's responding to it. So that's right. So you should be able to offer the whole thing. So let's see if that's the advice he gets, but that sounds right to me. You can't sever out the non-hearsay portion basically. So therefore you have to admit it all.
Was there I don't think there was an objection. You were starting this line of questioning.
Only because I didn't want to speak over anybody, but I am objecting to this line of questioning, and I do have a response if the court would care to hear it.
What is your response?
Well, Mr. Bangert has already testified that he could not hear Ken Paxton on the other side of that phone call. So he can't testify to this court that he's adopted any of the statements.
So that's a problem. So if he can't hear Paxton,
Mr. Harden wants
then
to
he can't
submit
offer it
Mr.
because
Mateer's
now it doesn't make any
testimony.
sense. Now it is just
Not made
hearsay
in court.
again.
That's hearsay.
Yeah, I agree.
If I may,
If he can't hear Paxton, it doesn't make
Counsel,
sense.
I didn't understand the first part of it when he characterized what the testimony was.
The objection
Is Paxton on? Is Paxton on this call or not?
But when he characterized what Mr. Mateer's testimony was, I just asked him to repeat what he said there because I just didn't get it. That's all I'm saying.
What I said was that Mr. Bangert has already testified to you and the jury, Your Honor, that he could not hear what Ken Paxton was saying on the other side of that phone call. And so there is no evidence that he adopted anything that Mr. Mateer said.
Yeah.
And so they're not his statements, and it still amounts to whatever Jeff Mateer said is still hearsay.
I think that's the better end of.
Sorry, we'd have to go back on the record. That's not my memory of Mr. Mateer's testimony. That's why I wanted to ask him to repeat.
We're going to have an argument over what the prior testimony was or not.
For 15 minutes with Mr. Mateer not being able to hear him.
I'm going to overrule. Be careful
Really?
as you move forward.
Overruled.
So this conversation, did Mr. Mateer give any indication he couldn't hear the Attorney General?
It became clear to me by listening to the
couldn't hear him.
conversation, it was about Nate Paul, and in particular, this question about retaining outside counsel.
Objection to
Unless,
Judge, may I be
unless
We just
like
went through that. He just
the
ruled on
person
this
that you're
Overruled,
hearing
overruled,
is
continue.
repeating what he
ahead, sir.
heard the Attorney General said.
It was concerning the hiring
So
of
if he
outside
said something
counsel
like, "Did you just say
to
blank?"
investigate these allegations that Nate Paul
then it would
had
be
brought to
a
our
present
office.
sense impression.
Can you put a date on it?
But that's not what we got.
Best I can recall, the conference took place maybe a week and a half prior to the end of September.
Was there anything in this conversation, as you heard from the other end, about him being disturbed that Mr. Pendley would not sign the contract?
Yeah.
Objection. The question calls for hearsay. He's asking what Jeff Mateer said on the phone call.
They keep calling the Senate the jury because the Senate is the jury.
Simply asking about
This
the
is a
conversation.
court of impeachment.
I've already ruled on this, Counselor.
Judge.
So, jury is correct.
Mr. Paxton was frustrated that we were not moving forward with the retention of outside counsel.
Objection to speculation. He didn't hear Mr. Paxton on the phone call.
This
His
is a
opinion
court.
of what Mr.
That's the
Paxton
jury.
is improper.
The court has just ruled 3
that's where we're
times on
at.
this issue.
It's fine.
My objection
Don't
is
think
to
about it too
Your Honor.
much.
Overruled.
Now, at the end of the conversation, during the course of this conversation, were the people for the meeting at Google having to wait till the General Paxton finished trying to get you to approve an investigation by Mr. Cameron?
I know we went right up to the wire. We may have gone a few minutes past it. I don't recall, but it was close, and it might have gone over.
Well, I'm wondering, is at the end of the conversation, did you have any new instructions as to what the two of y'all were to do about Mr.
Is it a real judge? It is the lieutenant governor who is not a lawyer.
I did not receive any instructions myself.
All right. As a result of that conversation,
Who is the
did
judge?
you do anything new
Because
or express any new concern about the hiring of Mr. Kamek?
I did nothing new.
did I mention it's a political court
was
yet?
heightened substantially.
It's a political court.
Let him finish the answer.
Counselor, he's answering the question that was directed.
Yes, Judge.
Yeah.
Overruled.
Thank you.
My concern based on that occurrence was substantially heightened because we were about to move into a very intense phase of the Google litigation, and the Attorney General's focus was on Nate Paul, not on the Google case.
So at the end of this conversation, who did you understand that the Attorney General wanted an outside counsel to investigate?
The law enforcement action concerning Nate Paul, that would have included the search of his house, his properties. The theory was that there had been an improper warrant obtained, and I believe there were also allegations of a conspiracy.
They gave 27 hours to each side, so this should end by mid next week.
And did it include investigating federal magistrates? 8 federal magistrates?
That's 3 days apiece.
Did it include investigating individual
Wednesday,
law enforcement officers
I guess.
in the FBI?
Yes,
Did it include investigating
Maybe Thursday?
CPS officers?
I believe so. I believe that's correct.
And did you know at that time, were there any members of the securities board that were also part of this that he wanted investigated?
I believe Mr. Saban.
And were you aware as to what both the head of your law enforcement division and Mr. Maxwell, because I'm not sure exactly what his title is, were you aware of what their consistent position has been all along on this matter?
Yes.
And in spite of that, was the Attorney General still insisting on going and investigating these people on behalf of Mr.
Yeah, I'm not even sure a sidebar even makes sense in this particular context.
To Austin,
because
when was
the
next
jury
time
can
you had any
overrule the
contact
judge
or were aware of this
on his
particular
rulings because it's political.
I was in a meeting at the governor's office.
That's the level of bizarreness you're at, right?
Brickman.
So I'm not even sure a sidebar
scheduled
even hypothetically makes sense. Because normally you have a sidebar so the jury can't hear it.
All right.
But here, the jury can overrule the judge.
I
So
received a text message telling me to return to the office, that something had happened. My immediate assumption was that something was Nate Paul.
Why?
Because we had been becoming increasingly concerned. We felt as if matters were coming to a head. The Attorney General was insisting that we move forward with outside counsel. We strongly resisted that. We, at that point, had become cognizant of the pattern that had developed over the preceding 9 months. And it was clear to me that hiring outside counsel to undertake this task could only benefit one person.
Then I'd object to that opinion. It's an improper opinion.
Wheezy says, so if you're saying I understand how the court system, I have to understand this new court system. No, you really don't.
It's his opinion, overruled.
Just remember it's political and you're already there.
When you were at the governor's
the rules are made up and the points don't matter. I keep telling you that because it's very true.
That
the Senate
received by any
is the judge, which means that they are God.
And
so if you don't have to learn the rules because there really are no rules in the end. There's the veneer of rules, and that doesn't really count.
And I'm only asking, were you aware of that call?
I was. The meeting at the governor's office took place on the same day that Ms. Mays received the phone call.
The rules only matter as long as they all collectively agree it matters.
On the 29th.
It's Tinkerbell. It only continues to exist as long as they keep clapping.
Counselor, overruled.
Now, when you were at the governor's office, was there somebody else with you from your staff? Was there another member of the Attorney General's office with you?
My recollection was Blake Brickman.
All right. And were y'all on totally unrelated normal business with the governor's office?
Normal business.
All right. So what did you do when you got that text?
Excused ourselves from the meeting, and we departed and went back to the office, the Attorney General's office.
And what time that day, on the 30th of September, did you return to the AG's office, and where did you go?
We went to the 8th floor and went directly to Mr. Mateer's office. And Mr. Mateer was there, Lacey was there, I believe others were starting to gather.
All right. And now, would you describe the atmosphere in the room? First of all, how many ultimately ended up in the room talking about this matter?
Mr. Maxwell was on vacation, but all the other deputies that were involved as the whistleblowers ultimately were there.
And what was the atmosphere?
Disbelief.
This isn't Busby who's doing the objections. I'm not sure who this is.
Extreme.
And is he using objections to disrupt the flow? Probably.
About? What did you learn that made you most concerned?
We had been following this pattern of Nate Paul and his interests metastasizing throughout the agency over a period of months. It had become clear to me, based on my conversations with the Attorney General, based on the lack of any substantiation for many of the claims that were made, based on the absence of a public interest in taking actions to benefit Nate Paul. Based on all of those concerns,
Counselor, I'm sorry.
I was
if you have an
asking
objection, raise an objection, but just interrupting, not helpful. I didn't hear an objection, and I just heard interruption.
I apologize, Judge, but I'm just intending to object because I believe that what Mr. Bangert is doing on the stand is not responsive to Mr. Hardin's question, and I have to lodge my objection so that he doesn't testify before the jury.
Counsel, I think he wants you sitting so the rest of us can hear you.
I couldn't
so we
see.
can hear you.
Just please sit. We can hear you better.
Right. I'm objecting while Mr. Bangert is speaking because he's testifying to evidence that I believe is not admissible, and he's telling it before the jury. And so I'm lodging my objection before it gets to the jurors, so it doesn't affect, inadmissible evidence doesn't come in and affect their judgment in this case. So I don't mean to speak over Mr. Bangert, Your Honor, but I do have to lodge my objection on behalf of Mr. Paxton.
I just did not hear the word objection.
The funny thing too is, like, even in the impeachment charges, it's all made up because there's sort of the catch-all, right? Which, when we get to the end of this thing, trying to assess this in sort of a legal framework,
I think you were.
It's almost a fool's errand.
Let me ask you this:
because
in the course of this conversation, first of all, you of course were not here for opening statements, were you?
No.
And you weren't here for.
Let me see if I can find the exact wording of this thing.
No.
If someone was contending that you folks were sitting around involving it in a mutiny, what would be your response to the suggestion that you folks were sitting around there cooking up a mutiny against the Attorney General of the state of Texas?
As in, we were. That would make no sense to me. We were trying to protect the Attorney General as much as we could.
As a matter of fact, over the last 9 months, what had been your mission in relation to the Attorney General as it related to Mr. Paul?
We had continually, in various ways, warned him about Mr. Paul. We had discussed with him the absence for any substantiated basis for taking actions to benefit Mr. Paul. We had been rebuffed.
During all that time, were you still a supporter of the Attorney General?
Yes.
Did you believe in the things that he was publicly saying that he believed and he wanted to do?
Yes, that's why we were there.
And did you, all that period of time when you were warning him about Nate Paul, what is your testimony in terms of whether or not you still were looking after the best interest of the public, but also the Attorney General?
Senior staff always has to walk that line. And our job, we take an oath to defend the Constitution of the state, but we also are loyal to our principle. And those two things, in almost all cases, are consistent with each other. So our job is both to protect the interest of the public and to serve at the pleasure of the Attorney General.
And when this meeting is held, by the way, I think you said the 30th, and I want to sort of put a couple events in your mind to see whether it's possible that meeting would have been the 29th, for you to let us know whether it's the 29th or 30th. You ultimately called and made an appointment to visit and go to the FBI during this time frame, correct?
Yes.
And you were over at the governor's office. And if the evidence is going to be unrebutted that you and your group went to the FBI on the 30th, when would this meeting, what is your testimony as to when this meeting that you've been describing would have been?
It would have been the day before. It would have been the day before, the 29th.
Okay. So this meeting where you come back over from the governor's office and you all meet together was on the 29th of September?
Yes.
How long by this time, had you been informed of what these subpoenas that had been served by Mr. Kamek were asking for?
Initially, we were aware of a subpoena to a bank requesting records relating to Nate Paul's financial interests. That was the first one that we became aware of. We subsequently became aware of others.
Did you become aware that these subpoenas were actually seeking information through the grand jury, a criminal state grand jury, of Mr. Paul's opponents in his civil litigation?
Yes.
Objection leading. My objection is that the question is leading, Judge.
I'll put it another way, Your Honor, real quickly.
Please rephrase.
Were you aware one way or the other, and if so, what were you aware of in terms of whether the subpoenas of Mr. Kamek were being used and drafted to help Mr. Paul in his civil litigation?
Yes, it became, as the subpoenas began to roll in and we became aware of them, reading them, they were consistent with his argument that he wanted to pursue action against both the law enforcement officials who had pursued the subpoenas of his house and his properties, as well as financial interests related to Mitty Foundation and I believe others.
Now, at this time, when this is all happening, what was there sort of a mood of concern? When you talked about shock, why were you shocked? What were you concerned about?
We were unaware, at least I was unaware, that Mr. Kamek had been taking any action on behalf of our office. I was unaware that he had been retained. I was deeply concerned that the name and authority and power of our office had been, in my view, hijacked to serve the interests of an individual against the interest of the broader public.
And the fact that he had invoked the use of a grand jury to try to help Mr. Paul in his investigation, what level of concern and why was that a bother to you?
It was unconscionable in my view. You were using criminal process to pursue the private enemies.
Objection.
I'm not sure grand jury is
Objecting to
inherently
improper
necessarily
opinion about
criminal.
the unconscionability of these actions.
I asked why he was concerned.
Overruled.
Thank you.
You
can pick back
it's not
up.
worth arguing.
Yes, in my view, the criminal process had been harnessed to pursue the business enemies of an individual, Nate Paul, who also happened to be under intensive investigation by law enforcement.
So how did you folks decide? I think it was 7. Was it 7 guys and 1 woman? I mean, so when I'm talking about guys or women or whatever, how did y'all decide? I mean, what kind of considerations did you give as to courses of action you should follow?
I'll speak for myself here.
That's all I want you to do.
As a staffer, you have fidelity to the Constitution and fidelity to your principal. Those two things should always align. Unfortunately, over the previous 9 months, they have been drifting further and further apart. One always assumes the best about their principal and attempts to protect that principal's interests, even at your own expense. When I saw that the subpoenas had been issued outside of the normal process of our office to pursue criminal process against private citizens to benefit one individual, it became clear to me that there was nothing more I could do, that the Attorney General was determined to harness the power of our office
And
to fulfill the interests of a single individual against the interest of the state.
And Judge, I would object to that answer. That
bet you
answer is
would.
speculation about his opinion of what the intent was of other parties.
Overruled.
Yeah,
Now-
that's not a fair objection. But it was a very good answer. A little rehearsed maybe, but it was a very good answer.
Did y'all try to decide what to do in terms of whether you hire outside lawyers yourself? Or what kind of issues were you concerned about as a course of action going forward, you yourself?
We had stepped into the void at that point. There's nothing
Stepped into the void.
map to follow when that happens.
That's sort of like what we're doing here, right?
Yes.
There's no real roadmap except for something 100 years ago and something in the 70s. You were writing on a clean slate, weren't you?
Yes, much against our will, but our hand had been forced.
So what drove you to make the decision to go to law enforcement?
In my view, there was simply nothing more we could do. The course of actions had.
I'll tell
played
you
itself
this. I
out.
find this guy a lot more credible
Attorney
than the first
General
guy.
was determined to follow this course of action in favor of Nate Paul, despite all of our efforts.
You may now
to
judge me
persuade him
accordingly for
otherwise.
that evaluation.
The power of our office had been fully, at that point, harnessed to advance Nate Paul's interests, and we had lost the ability to, as senior staff, protect our principal.
Mr. Bangert.
Oh, I'm definitely waiting for Cross, for damn sure. But even compared to the other guys direct, he's doing better in my view.
Repeatedly in this proceeding, that why didn't you just go to the Attorney General? Why didn't you go to the Attorney General? Just talk to him. Did you?
Concerns were raised repeatedly and consistently by multiple members of senior staff over a course of several months. There is no question in my mind, based on my personal experience with him, that he was well aware of our objections.
And in fact, after you went to the FBI on the 30th of September, on the 1st of October, did you as a group send a text message to the Attorney General asking to meet with him?
We did.
And before that, had you been aware that he was out of town when all of this happened to begin with?
Yes.
And when I say to begin with, on the period of September the 28th, 29th, do you know where the Attorney General was?
He was on a business trip out of the state. I don't recall which state he was in, but he was out of state.
And on the 29th or 30th, were you, what was the hurry that you experienced about trying to call this to the attention of law enforcement? Were you concerned what Mr. Kamek was still serving subpoenas out there to private people, or what was your concern?
That was leading to shit. Thank you. That was very leading.
He's insinuating the answer in the question, Judge.
He sure was.
I asked what his concern was.
No, you didn't. You gave him the damn answer.
My concern was we did not know what we did not know. We knew that he had already been serving subpoenas on banks. We were learning of additional subpoenas. In my view, we had lost our ability to speak into the situation as senior staff. We had no ability to end the use of our office to advance private personal interests, improperly using the criminal process. The only way we could deal with that situation was to make a report to the FBI. At least that was our judgment at the time.
Do you happen to recall why you picked the FBI rather than some other agency?
My recollection was that we had a relationship with some agents at the FBI who we trusted and we knew. And also the FBI, in our view, would have jurisdiction over these kinds of matters.
And in addition, DPS at that time was one of the people,
241, right?
Not that Mr. Paul was seeking to investigate.
Yes.
At the end of the day, how long when y'all decided to go to the FBI, how many of you went, and how long were the interviews?
7 of us went. We were interviewed together.
All right. And how long do you think the interview?
Multiple hours.
And once that interview was over, I mean, did you go yourself, knowing one way or the other what type of crime might or might not be involved?
I did not have the precise. I had a fairly good idea what was happening based on the evidence I had collected. Yes.
But did you, one way or the other, as a person not experienced in criminal law, did y'all sit down and decide what statute it was or anything?
I'm guessing
like
18 U.S.C. 241, 243.
About what kind of crime this witness believes was committed.
Just a rough guess.
I'll withdraw that question.
Sustained.
Thank you, Your Honor. Let me ask you this.
I'm not a criminal lawyer, and I have a pretty good
What
idea.
you've been doing on behalf of Nate Paul an abusive office?
Yes.
Objection to improper opinion. It invades the province of this jury's decision in this case.
Let me put it in.
Sustained.
Let me put it another way.
Counselor, try a little bit better.
Thank you, Your Honor.
Try better. That's cute.
Did you yourself, when you went to the FBI, have an opinion that drove you to the FBI about what this conduct by the Attorney General did, that the Attorney General was involved in, as to whether or not he was violating the oath of office that you were familiar with and believed he should be following?
Objection to that question. Again, same objection, Judge.
Overruled.
Yes.
And what did you think? Just you personally?
Objection to improper opinion in relevance to what this witness thought.
Overruled.
I went to the FBI because I believed that the Attorney General.
Just put the microphone up or move forward, but just move up a little bit if you don't mind.
Is this his sort of like big
FBI
close question?
Because I believed, based on my
Because it feels like it.
experience over
Like,
the
please
previous
tell
9
us all the
months,
reasons you
Attorney
think the AG
General
was guilty.
had abandoned his obligation to work on behalf of the interests of the people of Texas to serve the interests of one person, Nate Paul. And that was based on a series of events that occurred over several months.
Objection to non-responsive. He asked his opinion, not what he based it off of.
Sustained.
Now, after you folks went to the FBI, were you all together when you sent an email the next day to the Attorney General wanting to meet with him?
We did.
What was the Attorney General's response?
It was a very odd response.
What was it?
It was a text message saying that he would be happy to meet with us to address any concerns we may have or something to that effect.
Well, then did he agree to?
No, we did not meet with him.
How did that go? Did you know whether he was able to meet? Can I have the two exhibits? May have just a moment for Stacy. May I have just real quick?
Sure, Counselor, we're at our break time. Do you want to, I don't know how much longer you have with this witness.
I think only 5 or 10 minutes is all I have left with this witness.
Okay, we'll go about another 10 minutes.
Thank you.
I mean, it felt like he already asked his sort of big question and he's stepping on it. He had his big finished question and now he keeps going. Don't do that. Don't do that. Don't ask your big finished question and then keep going. When you have your mic drop, you got a mic drop. You know, you don't keep going.
Stacy, can you I believe this is in evidence, is it not? We check.
Before we put it up on the screen.
I'm told it is in evidence.
No objection, Judge, to 225.
No.
Continue.
All right.
If this gets lost in technical minutia, I'm going to be a little sad.
And explain to the jury if you can see it clearly on the screen.
Yes, I see the document.
All right. Do you recognize this document and this exchange of text messages?
It's been a while, but I recognize it.
All right. What I'm going to ask you to do, each text message identifies the sender. I'm going to ask you to publish this to the jury and the public, but keeping your voice up. It's a trick because you got to look in there. First of all, if you would, just start out with Mr. Mateer, identify the speaker, and publish this exhibit to the public.
Yes, the text message is dated September 29th, 2020. It begins at 3:02 p.m. The first text message is from Jeff Mateer to a group of us on a group text. Quote, "We have a major problem. The kid has served a subpoena on a bank. Showed up there in person at the bank." Jeff then sends a separate text with someone from World Class. And then he sends...
Did you later discover the person with him?
Michael Wynn.
Was Michael Wynn, Nate Paul's lawyer?
Yes, Michael Wynn.
So you have him out there serving subpoenas with the lawyer of the person that...
Did I get my 1,000 followers on TikTok? I was close. Let's find out.
That is correct.
Who you know is under federal investigation as you're going along.
That is correct.
Go ahead.
The next text from Jeff. "I need you guys to come back."
All right. Then let's go to the next.
No, but we did pick up an additional 17.
Same day.
So now we need 79 more followers on TikTok. So we're making progress.
Jeff Mateer
but not yet.
To the group from Maxwell.
And what does that? Do you have any idea what that's referring to? Do you remember?
I believe Maxwell had been communicating with us at that time about the events of the day and had provided his evaluation as to a letter that we had been writing.
And he was actually in Colorado on vacation, was he?
He was vacationing.
Yeah.
We'll make it pretty soon.
Then
we've been reliably picking up some with the shorts, so we'll pick it up pretty soon.
Not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today that is documented.
And what letter are you talking about there? Or is he talking, that you're talking about? Do you recall?
My recollection is that there was a letter that had begun to be circulated amongst senior staff, but I am reaching into my memory to recall this specific time frame.
Were you at that time drafting a document to be told to be sent to either law enforcement or to the Attorney General announcing? Do you recall? If you don't recall, just tell me you don't remember.
At some point during that date or the next, I was more or less helping scriven. I was a scrivener writing up documents including allegations concerning what had happened that day. Yes.
All right. Go ahead.
I'm trying to think if I've ever heard the word scriven before. I've heard scrivener,
it's the person who.
but I was to turn scrivener into a verb. I was scrivening.
Influence. I'm assuming that's Mr. Brickman.
Every day I'm scrivening and
I then respond, okay, sounds like we need to beef up the specific allegations.
Go ahead.
I then text again. So do we need to lay out the facts that led up to today's events, KP taking NP, that would be Ken Paxton and Nate Paul, to Moore, that would be Margaret Moore, obtaining the referral, demanding that we investigate facially bogus charges, refusing to take our advice that there is no prosecutable offense, demanding that we hire outside counsel, overriding our advice a second time, and apparently now authorizing an improper fishing expedition by private attorneys into a civil matter.
All right, and then you have another one right after that, do you not?
I do.
Go ahead.
I then continue. Or do we need to go further and describe the constant demands that we put the resources of the office at the service of NP's private interest? That's Nate Paul. Personally intervening in open records issues, demanding intervention in a charitable dispute over the objection of staff, demanding an informal opinion to apparently, parentheses, after the fact, benefit Nate Paul. And now, finally seeking criminal investigation of federal officials involved in a criminal investigation of Nate Paul.
Keep on going.
Maybe I'll run for Attorney
Could
General.
you please scroll?
Yeah.
Anyone want to nominate me?
Send
I'm available.
Text. All the while over the
Uncivil
objection
law
of staff,
for AG.
its pattern and practice evidence strongly suggestive of an improper motive.
All right, let me stop you there a second. Do you believe did you believe at this time that the Attorney General that could enter into contracts, even if all members...
Maybe I'll even run under the name Uncivil Law, and I'll practice under the name Uncivil Law. That'd be good.
He is the principal, and I believe he could.
All right. What was your position as to whether either ultimately, however, there might come a time...
I could be General
Attorney
Uncivil.
General, in exercising what he believed he had
That sounds
the
pretty
legal
good.
authority to do, could do something that became illegal by being used for an improper purpose. Did you have an opinion on that?
I did.
And what was it?
Yes, the Attorney General could use the lawful powers and authorities of our office for a patently improper purpose.
Patently.
Such as using the power of our office to benefit the interests of one individual citizen at the expense of the public interest. That is improper.
If, in fact, you reach a conclusion that that has repeatedly been done, in spite of consistent advice against it by the staff, what is your opinion where there ever comes a time that staff has to complain and say, enough is enough? You can't do this
Improper
anymore.
opinion.
Overruled. Do you sustain it?
I'm sorry, overruled. He has the opportunity to offer his opinion.
Yes, Judge.
Yes, and that is precisely what we did.
Did you consider it a mutiny?
It was not a mutiny.
How would you characterize it?
We were protecting the interest of the state, and ultimately, I believe, protecting the interest of the Attorney General, and in my view, signing our professional death warrant at the same time.
What was the stated awareness of all of you that knew the consequences of
I suppose that's an
you
interesting
did
question for
when you
military
stepped
law
out this
sometime.
position
Under what
and decided to
circumstances,
go
if
to law
any,
enforcement?
could like an executive
We understood the gravity
officer
of that act.
get
We were
together
fully
with
cognizant of
other
it. It was something
officers
that we did
and
not want to do.
overthrow the
It was
captain of a
something that we
boat
tried
without it being a
earnestly to
mutiny?
avoid ever having happen?
That's an
But when the
interesting legal
moment
question.
came and we
I assume it
realized
must be
there was no other
possible.
choice,
I don't know.
That is the duty of a public employee, to ultimately make that incredibly hard choice to serve.
Yeah, there's a good question. Under what circumstances,
of your principle,
if any, can an XO gather together with other senior members and depose a captain without it being a mutiny?
Conduct.
Mr. Banger, did every single one of you
Have I ever watched JAG? I have watched JAG, yes.
for what you did?
Objection to improper opinion. It invades the province of the jury with regard to an article.
Sustain. Rephrase.
Banger, what happened with you?
That was the plot of Crimson Tide. It was the
Your
plot of Crimson
employment
Tide.
with the Attorney
Yes,
General's office.
it sure
I
was.
resigned from my position immediately after.
However,
the
I
2020
didn't
election.
assume that Crimson
By the time I
Tide.
resigned,
I did
all
not
of my
assume
duties had
that
been
Crimson
taken from me.
Tide was necessarily
I
based on the
was
finer
simply
points of actual military law.
An employee in
So-
name only.
When you
I didn't assume that
actually went to
Crimson
law
Tide
enforcement,
was
how
trying
do
to
you
teach
mean
me
your
the
duties
finer
were taken
points
from you?
of when it's
Over the
legal to
course of
depose a
several
captain.
weeks, I was excluded from and ultimately removed from any responsibility by the new first assistant. And then subsequent to that, in the middle of October, I was informed that I would no longer be overseeing the special litigation unit. I objected to that, and that was to no avail.
Counselor, you said about 10 minutes. We're for the benefit of the jury and the staff. Do we want to break here, or do you need a
That's
few more
fine.
minutes?
I want to have a few minutes, but that's fine. That's
You want to
fine.
if you have a few minutes, finish with the witness. If you're going to go longer, then tell me and we'll break.
Thank you so much. I never want to be in the way of people taking a restroom break.
All right.
Thank you.
We will break until 11 o'clock sharp. That's a 20-minute break, members.
Yeah, Crimson Tide didn't have assistance from the Navy. That's right. You're exactly correct. Amazingly, the United States Navy did not want to assist with a plot line that involved, overthrowing a captain. They weren't super thrilled with that plot line, so they didn't help. Yeah, that's true. All right. So basically, anyways, moving past that question for the moment onto this guy. So I find this guy more credible overall, and he's testifying about several different things that lead to an overall pattern of conduct that is suggestive, right? We see, according to him, of course, according to him, we have the Attorney General drafting this memorandum, at the last minute under hurried circumstances, going outside normal processes. We have the Attorney General wanting him to meet with Mr. Paul in order to get his perspective as it relates to an intervention into a charity that the staff does not believe the Attorney General's office should be investigating, and, doing improper things that way. We've got this hiring of this outside counsel that's being done in a way that's abnormal and using criminal processes, the grand jury using a criminal processes apparatus at least to get things to help benefit a particular person. And that, he's been constantly counseled, not to do these things, and he keeps doing these things. And so this has been going on, so there were a couple things where he testified is like, these things, individually are questionable, but as a pattern of conduct, raise a more questioning concern, I believe was his word of choice. We'll go with that. And I think there's value to that, and I find him to be a credible witness. He seems to just be a genuine guy. He's in his relating of the events. He seems to be relating the events in a way that I find to be credible, that I find to be believable, and that he believed that there was a problem that was increasingly apparent, ultimately requiring them to go to the FBI for, color of law offenses under U.S. code and so forth and so on, because they were so concerned about what was happening. And, they were, and I mean, to be fair, of course, he would have taken an oath, like we all do as lawyers and government officials for that matter, taken an oath to the Constitution, right? So, there does come a point somewhere along the line, by necessity, where you're like, well, that's an unlawful order, right? And you have that concept in the military too. Like, that's an unlawful order. So, but of course you have to be, you better be right. Of course, that's the trick, you know. If you're going to refuse an order from your commanding officer, you know, you better be right. But, you know, there is a point where, of course, the commanding officer's order could be illegal. And he'd be like, no, we're not doing that. So, you know, he seems like a genuine guy who takes his perspective seriously. Now, I'm totally willing to change that assessment on cross. But at least for the moment, and I just find his direct more credible on the whole than the first guy's direct. He just seems like a genuine guy who was very concerned and takes his oath responsibly, and he recognizes the authority of the Attorney General Act. But, of course, it is quite correct that the Attorney General could use his powers in an illegal way. Just because you can do something legally doesn't mean you can necessarily... Just because you can do a thing legally doesn't mean that because you did the thing it was legal. Which is fair, right? Just because I can do a thing legally doesn't mean that because I did the thing it was legal. Because if I did it for corrupt reasons, improper reasons, bribe, corruption, whatever, right? The motive behind it, right? If my motive is to serve Texas, then it's legal. If my motive is to benefit my crony, not so much. So the motive and purpose behind it transforms the same exact act from the legal to the illegal, which, you know, fair enough, common concept in law. Not, you know, nothing up our sleeves here. We understand this very much. You know, this is you know, nothing up our sleeves. It's perfectly reasonable. So I find him genuinely credible, and I'm willing to look forward to cross-examination because, you know, there might be things that he'll expose. That's what the purpose of cross-examination is, right? To test and to expose. And I think here's the challenge. I think in cross, I think that the idea of attacking them individually. Yeah, maybe you try to attack them individually and so the whole thing collapses, maybe. But you might have to try to, like, undo the collective as well. Because, you know, we'll see. We'll see what their strategy is. Like, you can attack the AG memo by... I already gave some suggestions on how to attack it. Just, like, off the top of my head. Like, I'm listening to this for the first time, and I already came up with an idea of how to attack it. Just say, you know, this is not an opinion within the meaning of the statute because he has a freedom of speech and he can say stuff, you know, in a more sophisticated version, but you can do that, right? And that's a defense. And you could say, like, for example, you know, the Attorney General had a different perspective on some of these issues and wanted to try to convince you that it was correct because, you know, political appointee. And he has the power to make the decision and he has the right to make a perspective. And, you know, for example, like in the rules of ethics, for example, like an attorney can defer to a senior attorney's ethics opinion unless, of course, it's just blatantly bullshit. So is this one of those times where, like, it was blatantly bullshit, or did you assume things, and maybe it goes to knowledge that he didn't have or evidence that he didn't have, and so he was drawing reasonable conclusions but from an incomplete picture, and to show things that he didn't have and show what the more complete picture looks like. A vantage point argument. Yeah, from your vantage point this looks reasonable, but let me show you something from a different vantage point and what you didn't see, that kind of idea. So there's a couple ways to go about attacking this, and we'll see. There's a couple ways to go about attacking this, but yeah. And as to people on ads, I honestly don't know if there's any way for me to turn off ads completely. So we'll just have to deal with the ads, I guess. So anyways. But part of this also, when we get down to trying to assess this in, let's call it a legal sense, because I don't know what else to do because I'm a lawyer. So I'm going to try to assess this legally because I don't know what else to do. When you try to assess this in a legal sense, Like some of these later charges are so vague that when you try to ask me a question, like when you get to me and you're like, okay, are you going to go guilty or not guilty? I swear in the end, which by the way, I'm not making a decision now. But when I get to the end, I'm like, I don't even really know the question I'm being asked, which is because guilty compared to what? And just to give you an example, like for example, in Article 19, just to pick one. These are problems of the later articles. Article 19, unfitness for office. While holding office as the Attorney General, Warren Kenneth Paxton engaged in misconduct, public or private, of such character as to indicate unfitness for office, as shown by the acts described in one or more articles. What the hell does that mean? The answer is it kind of means anything I want it to mean. It's a catch-all, right? It's sort of a catch-all. Is he unfit for office? How do I decide? Because he's unfit for office. So, it's, you know. Article 18. While holding office as the Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oath of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described in one or more articles. What does that mean? Kind of anything I want it to mean. Kind of anything I want to mean. So when you get to, are you convinced beyond a reasonable doubt? I'm just kind of like, I don't know. So yeah, we have some problems at the end of this pipeline, because it's kind of like, hey, do you think he's unfit for office? Which, by the way, again, because this is a political process, this is fine, right? This is fine, right? It is long established that you don't have to impeach someone for something that's criminal. Because, for example, when it talks in the U.S. Constitution about high crimes and misdemeanors, and I don't know the exact language in the Texas Constitution, but I'm betting it's similar. When it talks about high crimes and misdemeanors, what it means is political crimes. When it says high crimes, what does it mean? It doesn't mean criminal crimes. It means political crimes. What's a high political crime or a political misdemeanor? Anything you want it to be. It's magic. It's anything you want it to be. Because especially in the United States system, because the House, for example, is the sole body to impeach, and the Senate is the sole body to judge, which, by the way, is parallel in Texas. The House impeaches, and the Senate judges. They're the sole arbiters. What does it mean? Anything they want it to mean. Because that's what it is. It's political. It's political. So it's a very strange system. It's a very, very strange system. So, you know, the dream scenario, obviously, is that you don't need that. The dream scenario is that you find beyond a reasonable doubt as to a criminal charge. And you were like, you know, take away some of the procedural stuff, which, take away the fact that there's some procedural differences and kind of ignore that, and just kind of say, does the evidence as admitted through this strange and confusing mechanism, but does the evidence as presented convince me of this criminal charge beyond a reasonable doubt, like I was sitting on a criminal jury? That's the dream scenario, because then it becomes a lot easier. Because although it's still political, we get to pretend it's not, because we have the cover of, an actual crime. So that's nice. And even though we're convicting him of something that's criminal beyond a reasonable doubt, the only penalty is throwing him out of office because it's political. Yeah. Carl Granger says, have coffee on me, love your work. Thank you. Yeah. So, yeah, any kangaroo flags in the courtroom? It's a little bit of a kangaroo court. But then again, it was designed to be. It's political. It's political. So, yeah, the rules are made up and the points don't matter. And it's like, yeah, the Senate adopted rules, but then again, they're the ones that adopted the rules. And then again, the interpretation of those rules mean anything the majority of them agree it means. So it means whatever a majority of them agree it means at any given time. So that's fun. And they can't be wrong because it's political. So that's where we're at. The jurors are the senators. The jurors are state senators. The judge is the lieutenant governor. The judge is the lieutenant governor, and the jurors are the state senators, duly elected by their constituents. Did I mention it's political? Yeah. Yeah. Is it beyond a reasonable doubt? Yes. According to the rules, it is. If they decide beyond reasonable doubt means something other than what it means in a criminal context, though, I guess that's also okay. They adopted legally sounding words. But we're not inside a legal process. We're inside a political process. So, yeah. The decision cannot be appealed. No. There is no appeal. So, yeah. But for better or worse, I, on civil law, will try to give you at least one honest man's opinion as best as I am able. I will try to assess the evidence as best as I can in my judgment and try to reach a conclusion that I think is correct. And I'm going to treat them like laws because I don't know what else to do. Because if I treat them like politics, it means anything I want to mean, and that kind of sucks. So I'll treat them like legal principles and treat it like a lawyer and go from there. And I'll try to give you one honest man's opinion at the end of this as to whether or not I think Ken Paxton is guilty. So far, I think the prosecution has presented some credible evidence that Ken Paxton engaged in ways that are at best abnormal for what seems like corrupt motivations. So I'd like to hear more. But you have piqued my interest, prosecution. You have piqued my interest. And I hope you don't run out of time, which seems like a distinct possibility at this rate. Thank you, Jules Buddha, for the gift memberships as always. Jillian says individual voters are in fact less than 1-to-1 about everywhere in the country thanks to zoning. I'm not sure what you mean. Every 10 years they redraw the lines because that's where the census is. So they just redrew the lines. So the maps, and some states are in the process of still drawing the lines because sometimes it takes a little while. But yeah, every 10 years they redraw the lines so that there is a even population split for the state house and state senators, and for the U.S. House for that matter. Lucentel says, I'm curious how they didn't think that more than one person would benefit by clarifying the home buying rules in one direction. It isn't necessary to prove the charge that it only benefited Paul. But it isn't necessary. It would be sufficient, in my humble opinion, it would be sufficient to show, although it benefited other people, the primary motivation, or at least a significant motivation, how about that? A significant motivation of it was to benefit Mr. Paul. So the fact that other people benefited was from the point of view of the people drafting it ancillary, right? Other people benefited, but that wasn't the reason. The reason was because we wanted to benefit Paul. That would be sufficient in my view. That's corruption. That's corruption, right? If it just so happens to benefit Paul, that's not corruption. If we did it to benefit Paul, that's corruption. You see the difference? So our motivations go a long way. And that's also true criminally, of course. In a criminal context, that's also true. Motivations go a long way to determining whether something is legal or illegal. The exact same activity might be both legal and illegal, depending on the reason the person's doing it. You know? Corrupt purpose or corrupt motive goes a long way. Starlight says, what happens when the census is done, restrictions occur, and then people move to states with less restrictions in 21, 23? Well, again, this is a situation where I think you can answer your own question. As I mentioned before, they do the census every 10 years. So you tell me, what happens if there's a massive population swing as people move from state to state in 21, 22, and 23? What happens to the lines? Come on, you know the answer to the question. Answer your own question. I believe in you. Exactly what I'm saying. That's a problem. I'm not the only one with voting. Well, I don't know what to tell you. The Constitution of the United States calls for a decennial census. So that's what they went with, and that's what the Constitution says. So to the extent it's a problem, it's what the Constitution says. So, as always, amend the Constitution. You think you found a flaw in the Constitution? You wouldn't be the first person. I don't know what to tell you. It's what it says. Change it. I don't know what to tell you. We got some gifts sent. Let's take a look at some gifts while we're waiting. By the way, Tony, I saw that you bought my mug, Learning from the Misfortunes of Others. Should we take a look at the mug? Let's take a look at the mug, because we can. Hold on. Switch this real fast. Tony, one of our mods, bought this wonderful mug from my store. Learning from the Misfortunes of Others, the coffee mug. Tony decided to buy it with orange. It comes in your choice of colors. I believe it comes in 5 different colors. I believe it comes in yellow, red, orange, black, and something else maybe. Blue maybe, or something, I forget. But yeah, you can get this mug. This mug can be yours. And it looks pretty good, I have to say. It's a good looking mug. So if you'd like to get the mug, it's available on the merch. So, yeah. Anyways, what was I saying? Oh, yes. We were doing super chats, and I wanted to acknowledge that someone bought one of my merches. So, because that was nice. All right. Let's see. Where were we? Keith. Keith hit that beautiful, beautiful join button and became an uncivilian for the low, low price of 99 cents a month.
Come to order.
That's true. For 99 cents, you can become an uncivilian. EMT2666 said, don't live in Harris County. Walter County is cheaper. Mike Middleton said, coffee and granola bar on me. Maria Z gifted 10 gift memberships. Carl Granger gifted $10 to say, have coffee on me, love your work. And Jules Buddha, patron to the cause, continuing supporter, gifted 20 gift memberships because Jules Buddha kicks ass. And Frankenstein also gifts 5 memberships. Thank you very much.
Mr. Hardin, you can continue.
Thank you very much, Your Honor. Stella, can I have hard copy exhibits for the court and the other side on Exhibit 571? And can you give the witness one so that it doesn't have to be put up on the screen?
Is this already in evidence?
It is not. That's what I'm going to seek to introduce. Thank you, Your Honor. So now, without going in to specific contents, do you recognize this exhibit?
Yes.
Composer C says, "Bra, get organized before court starts." I don't know, Composer. I thought we hit it pretty well. Damn.
Would you identify it?
I thought we hit it pretty well by getting back to when court started. Damn, man.
Message that was sent
Shit.
I'm sorry.
You're a harsh critic.
Text message that was sent by the group of us to the Attorney General.
All right. And does it also contain the Attorney General's response?
Yes.
Are you aware of people of any instance?
Ann Bell Feinstein says, "Check the name again and tell me where the R is located."
Attorney General.
The R is located inside my heart.
That criticism.
I hope you're doing well, Ann.
All right. Now, Your Honor, we move to introduce.
Oh, you were talking about Rusty? Oh, okay.
This witness participated in sending this, along with the other group of people we've been talking to as the whistleblowers.
Any objection?
No objection, Judge.
Continue.
All right, can I have it up on the screen, please? The first page, would you show who
Each side has 27 hours.
For the record, explain who all it says is sending this.
The beginning at the top of the page,
Yes.
Lacey Mays, Deputy for Administration, is sending this email, which contains a screenshot.
I noticed as I was rewatching the live stream from yesterday, because yes, I do watch. I rewatch my own content because I'm that guy. I noticed I was rewatching the stream yesterday that during one of my larger monologues, someone in chat was like, "Be quiet, we can't hear the questions," and I'm just over here like,
of the text messages that
welcome to my channel, you know.
She's up at the top, sent to the Attorney General.
I talk when I want to talk.
And did you send it on what date, if you would look up there?
The date is not listed, but this would have been...
The screenshot is dated, is it not?
The
Can you see it?
screenshot...
Yeah, the first page.
Yes, this is the email is dated October 1st.
Right. The email has been sent around, but if you look at the second page of this exhibit, does it contain correspondence with where each of you let me back up. Strike that, and I apologize, ma'am. If you just give the jury the background of why y'all sent this and when you sent it.
Yes. We sent this message to the Attorney General after we had made a good faith report to the FBI. We wanted to speak with him. We wanted to bring him back to the office, or we wanted to invite him back to the office to speak with us so that we could address these concerns head on. We were hoping that we could finally resolve these issues and, in our view, end this unlawful use of our office's resources.
All right. Now, the screenshot was dated October 1st, and in fact, your group went to the FBI, I believe you testified, on September the 30th, correct?
That's right.
This email that Jeff sent on,
You're trying to make bagel pizza in your air fryer? That sounds pretty awesome.
The text message?
I haven't had bagel pizza in a while, but my memories are fond.
Here at 12:49 p.m. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law.
Nice and slow.
I'll begin again. General Paxton, yesterday, each of the individuals on this text chain made a good faith report of violations of law by you to an appropriate law enforcement authority concerning your relationship and activities with Nate Paul. We request that you meet with us today in the 8th floor conference room at 3:00 p.m. to discuss this matter.
Now, at that time, since when it says yesterday here, and I believe you testified that the two of you went to the FBI on the 30th, correct?
The group of us did.
Yes, and then on the 1st, you send this text. So when we see on there today, 12:49 p.m., this message from Mr. Mateer on behalf of all of you would have been sent on what day?
The following day, the 1st.
October the 1st. And at that time, did you know whether or not the Attorney General was back in Austin from his trip out of town?
Yes, my recollection is that he had returned late the previous evening.
Late the evening of the 30th?
Yes, that's my recollection.
Okay. Would you publish to the jury what he responded to you about 3 hours after you sent it?
Yes, at 3:08 p.m., Jeff, I am out of the office and received this text on very short notice. I am happy, as always, to address any issues or concerns. Please email me with those issues so that they can be fully addressed.
And so did you email him with those issues?
I don't believe we did. I don't recall. We wanted to meet with him personally.
And if you did not, why would you not have?
He was well aware.
And how did you take that, asking for the issues?
I interpreted that message as he was not going to engage with us on this.
Did he ever reach out to and try to?
No, not to me.
And as a former deputy first assistant, you remain still with the office, available to talk to him for how long?
I remained with the office until after the 2020 election in November, early November.
At any time after you sent that text, did the Attorney General ever attempt to discuss any of these issues with you?
One time.
When was that?
I had turned in my notice of resignation. I was in the process of gathering up the things in my office, and I was alone in my office, and he walked into the office unannounced and closed the door behind him and was pacing to and fro in the office. He was very agitated, in my view. And he said to me, "Ryan, I just want you to know that you're only sitting in this office today because of me."
What else did he say?
He said, "This was not Jeff Mateer who put you here, it was me."
He said what?
He said, "Jeff Mateer didn't put you in this office. It was not his decision, it was my decision. I put you here."
Okay.
And it was a very odd conversation. I wasn't quite sure how to respond, so I just told the Attorney General that it was my hope that God would work things out in the end. That was the only time that he spoke to me alone about these issues, and that was it.
What is your observation as to whether in encounters of unpleasant or difficult issues, the Attorney General's characteristic is as to how he acts in issues of conflict or whether he avoids them?
Objection to relevance.
Sustained.
After you left, could you describe for the jury the impact of all this has been on you?
Yes. That month was a very unsettling month. I was waiting to be terminated. Instead, I just had my job duties stripped from me and was left more or less a man without portfolio in the office. I watched as my fellow whistleblowers were placed under administrative leave and investigated. I watched as certain members of the staff, the new staff, treated them in a belligerent manner, including myself, and ultimately I resigned. It was incredibly heartbreaking because I had believed in Ken Paxton and what he had been doing for years. I had moved my family here to Austin specifically to go to work for him. And I watched all of these things that we had done as a leadership team slowly begin to unravel. And it was absolutely heartbreaking to see that happen to an office that had been, in my view, a beacon for the conservative legal movement for years.
Have you noticed he's not even here today?
Objection to relevance.
That's very relevant. I want the record
Objection
to
to
reflect.
relevance.
If I could, I'll ask that question again.
Sustained.
All right. I want the record to reflect that Attorney General Paxton was not here entirely. I'm just making this for the record. I think we're entitled to point out.
I'm objecting to the attorney testifying.
Excuse me, let me finish, please.
Quit talking over each other. Court reporters cannot record. I sustain his objection.
Yes, sir, I understand, and I'm not any longer trying to ask that question. I do want the record to reflect that neither yesterday nor today has the Attorney General graced us with his appearance. That's all. I wanted to make that statement, please, for the record.
I mean, it is pretty typical to
very
note
much,
appearances, so I don't see any problem with that.
I'll pass the witness.
Like you would.
Judge, may I have a moment to just prepare my exhibits up on the bench or the?
At least in court, you'd almost start. In fact, not only every day, you start every session with appearances, like who's here, and you make a point of noting that the defendant is there, which they of course always are, but you make a note of it for the record. So I don't think there's anything improper with basically making note of appearances. So I think that's fine. And he just passed the witness over. Okay, so we'll see what they do on cross. But I find him very credible.
May I proceed, Judge?
You may proceed.
Let's see what we got.
Mr. Banger, we heard a lot about your background. Obviously, you have a very esteemed career and resume, correct?
My resume is what it is.
Okay. Mine's not like yours, and so I'm just going to try and do a courtesy to you and ask you short and simple questions, okay? And I'd ask that if I ask you a yes or no question, that you simply respond yes or no, all right?
Understand.
Okay. Now, you are currently represented by an attorney, correct?
I am.
Okay. That attorney is Johnny Sutton.
Yes.
That is the same attorney that represents Jeff Mateer, correct?
It is my understanding that he also represents Jeff Mateer.
Okay,
Yes.
So you and Jeff Mateer both have the same attorney.
We do.
Okay. As a matter of fact, Mr. Sutton is here today in the building, right?
Yes.
He's probably watching your testimony.
I assume so.
Okay. And as a matter of fact, the two of you were just in the restroom together about 15 minutes ago?
You would know that because you were there too.
I know, right? But that's a yes, correct?
That is a yes.
Okay. So you guys have been in contact during your testimony in this trial?
We have.
All right. Now, you stated on direct examination that you did not provide any statements with regard to what you've testified in court today, right?
Could you please reframe? I don't understand the question.
Sure. And I think the record reflects when Mr. Harden asked if you made any statements in this case, and when Judge clarified if you had made any statements before this testimony, you said that you hadn't.
I do not recall testifying to that effect.
Okay. So you've made statements previous to your testimony today, right?
Again, when you say statements, have I spoken to anyone?
I mean, you have made an out-of-court statement, Mr. Bangert.
Are you talking about under oath?
I'm asking you yes or no, have you made statements about this case to anyone?
You may answer the question. What's your objection?
My objection, Your Honor, is if he would just please express what he means by statements. That has a legal significance and a practical one.
Overruled.
This witness is not aware of the issue.
Overruled. Answer
Yes.
the question.
So
It's a yes or no question.
it's not a yes or no question.
Well, then
sir.
let me ask you a more specific question. Were you interviewed by the House Board of Managers in their preparation investigation of this case?
Yes, I was.
Okay. Were you interviewed by Mr. Harden and Mr. DeGuerin prior to your testimony for this case?
Prior to my testimony today?
Yes.
I was, yes.
Okay. So those are two statements that you've made to people about your testimony in this case, right?
I'm not trying to fight with you, counsel. I'm simply pointing out that the word statement carries legal significance, typically under oath.
Well, hearsay is
Those are not under oath.
Yes.
Witness,
Yes, ma'am.
answer the question, not argue with the counsel.
You've made 2 interviews prior to testifying today, right?
I have given interviews, yes.
Okay. 2 of them.
I have spoken both with the House Managers Council and I've spoken with Mr. Hardin and Mr. DeGuerin.
Yes or no, Mr. Bangert? Were either of those interviews recorded?
No.
Did you ask that those interviews not be recorded?
No.
Did your lawyer ask that those interviews not be recorded?
Not to my recollection, no.
So you don't know why they were recorded? Why they were not recorded?
I do not.
Okay. If Mr. Hardin or Mr. DeGuerin had had any objection to you being recorded during your interviews, would that have been a problem, yes or no?
I don't understand the import of the question.
I don't understand the question either.
For me?
My question is, if Mr. Hardin or Mr. DeGuerin had said, Mr. Bangert, you're giving an interview with regard to testimony in an impeachment trial, can we record you? Would that have been a problem for you or Mr. Sutton?
I can speak for myself. I would have no problem with that.
Okay. And despite your lack of objection to that, Mr. Hardin and Mr. DeGuerin chose not to interview you during your interviews with regard to this case?
Chose not to record me.
Yes.
I assume that was their choice, but I was not recorded.
Okay. And additionally, prior to that interview, when you met with the House Board of Managers,
This is some weak shit so far.
safe to say you wouldn't have had an objection to them recording you either, correct?
I can't think of any at the time, no.
Okay. And it just so happens that the House Board of Managers, the investigators in this case, chose not to record your statement either.
As far as I know, they did not.
Okay. So you would have to agree that there are a lot of things that you testified to when Mr. Hardin was directing you that we were hearing for the first time on this side of the trial, correct?
I honestly cannot answer that question. I do not know what you know and what you do not know.
Okay. Well,
enough.
you had information that you produced actually to both sides of this trial within the last 2 days, correct?
There was a text chain that was produced by my counsel.
Okay. We didn't see Mr. Hardin produce those text messages during his direct, did we?
Mr. Hardin producing his text messages to whom?
During his direct examination of you, he did not ask you about text messages that you produced yesterday during this trial. Yes or no?
No, he did not.
Okay. Your Honor, may I approach the witness?
What the hell are you asking about? So far, this is like the stupidest gotcha ever. Didn't you say you didn't make any statements? Yes. Well, isn't it true that you gave testimony to the House managers? What the fuck kind of
Don't
question
speak
is
to him
that?
Now, just give it to him and then speak from the microphone. Thank you, Counselor.
I'm handing you.
Hold on. Everyone wants to hear you.
I'm handing you what has been pre-marked as Attorney General's Exhibit 1000 and I believe 3, correct?
It is marked AG 1003, yes.
Okay. Now, you recognize this document, do you not?
Did they record it? No.
I do.
These are
Isn't it
text messages
because
from
you
your cell
didn't
phone,
want it?
right?
No.
Yes.
What the
You
fuck?
produced these to both sides in court yesterday.
Mr. Sutton, my attorney, produced them yesterday.
Okay. And you would agree that these are a fair and accurate...
Counselor, excuse me, we do not have a copy of
Yes,
what you
Judge.
have.
If you have a problem with when something was produced, that is not a question for
You would
this
agree that
witness.
these are a fair and accurate
Your Honor,
reflection.
pardon me, Your Honor, we were not given a copy of those. Could we have a copy of them, please?
If you have a question with the timeliness of production, that is not a question for the witness. You know?
I'd ask the
It's
record
like-
reflect that I have tendered to opposing counsel a copy of their witnesses' text messages.
Let the record reflect.
Now, Mr. Banger, you would agree that these are a fair and accurate reflection of the text messages between you and Ken Paxton in July and August of 2020, correct?
Give me a moment.
Yeah, it's like if you want me to read it to make sure it is, then yeah, I'll take a second.
With the only modification that the first text message is in June.
Okay. Well,
It goes through
your
August.
attorney produced these, so presumably he got them from you, right?
Yes.
Okay. Otherwise, fair and accurate reflection?
Yes, they appear to be.
Judge, at this time, I would move to admit AG Exhibit 1003.
Any objection?
No objection, Your Honor.
Show the
This better be
exhibit
good.
being entered into the record.
Okay.
Admitted to evidence, excuse me.
Thank you, Judge. Mr. Bangert, you talked about two very, very, very specific conversations that you had with Mr. Paxton that I think stood out during your testimony. The first one of those was a conversation at Polvo's, correct?
We did, well, Nate Paul was part of that, but
Right.
we were at Polvo's at lunch together with Mr. Paxton, Drew Wicker, and Nate Paul.
And the second conversation was essentially a conversation that you overheard Jeff Mateer was having, right?
The conversation at the Raga meeting in Atlanta, yes.
Okay. Two separate conversations.
Yes.
Did you provide, I don't recall, did you provide dates of those, specific dates of those conversations during your direct examination?
I do not believe I did.
Okay. Now, you talked a lot about your experience and your resume. I think you've clerked, you've worked at, was it Baker Botts as a partner, right?
I have both clerked and worked at Baker Botts as a partner, yes.
You've worked at executive level positions in 2 attorney general's offices?
Yes.
You didn't get there because you don't have an attention to detail, right, Mr. Bangert?
I'd like to think that I pay sufficient attention to detail.
Right, and you document things that are important to you, do you not?
Not always.
Not always? Okay. Well, let's talk about that. You had documented in this case something that you thought was very important, the foreclosure opinion, did you not?
I made a document that outlined my concerns about, oh, sorry, you said the foreclosure letter?
Yes, the foreclosure letter.
Well, I was shown the foreclosure letter today, yes.
At this time, I would ask Eric if you could publish the House Board of Managers Exhibit 119.
What are you talking about? Do you have any questions for him,
This is
Counselor, or
an
not?
email that you sent to Ryan Vassar on September 30th.
Counselor, excuse me, has this been entered into evidence?
My understanding is it has. If not, Judge, I'll ask to enter. It's the House Board of Managers Exhibit. At this
If he's a
time,
lying liar, he hasn't shown that yet, Jan. Come on.
Admitted into evidence.
Thank you, Judge. Now, Mr. Bangert, this is an email that you wrote to Ryan Vassar on September 30th of 2020. True?
Yes.
September 30th of 2020 is after you had the meeting with the other executives about going to the FBI with regard to Ken Paxton. True?
This is at 9:29 a.m. that morning. We had not visited the FBI at that point.
Okay, it's the same day that you had a conversation with the other executive level AGs about going to the FBI, right?
We did on that day.
Okay, and September 29th, or excuse me, September 30th, that's 2 months after you ever drafted the foreclosure opinion that you talked about during your direct examination, correct?
Slightly under, but about 2 months later, yes.
Do you typically write memorandums about things that happened 2 months ago? Yes or no?
No.
Does it stand out to you, or does it seem odd to you to wait until the day that you go to the FBI or the day before you go to the FBI to write a memorandum about something that happened 2 months ago?
No.
Not odd at all?
No.
Okay. Now, to be
No.
clear, yesterday during
This is-
Mr. Hardin's testimony, he at one point said, I think by the end of July, beginning of August, you had been a part of 3 issues that related to Nate Paul, right?
Yeah, I don't perceive that as a lie, Mark,
Depending
but
upon
you
how
do
you count
you.
the open records issues as 1 or 2.
Okay. Well, you have the open records issue, correct?
Yes.
Your involvement in MIDI,
I was involved in MIDI as well, yes.
okay? And then you've got your foreclosure opinion involvement.
Yes, that is correct. I was involved in all.
And as a matter of fact, a lot of those almost overlapped each other, true?
At the edges and at the margins, they did overlap.
Okay. Now, yesterday you testified to the jury that you had a boiling concern about this, correct?
I did have boiling concern about this.
Now, to be clear, House Boards 119, your email to Ryan Vassar, is the only memorandum and summary that you drafted with regard to any of your involvement with MIDI, open records request, or the foreclosure opinion. Yes or no?
I can't recall.
You can't recall. Okay. Well, we didn't see any other memorandums, have we?
I haven't seen any in the trial today.
Okay. Well, you would have produced it, so you'd know about it, wouldn't you?
I produced everything I had.
Okay. And all we got was this email.
I produced far more than this email.
Okay.
Nice, good answer.
Now, I want to backtrack a little bit, and we'll go back to that correspondence between you and Mr. Vassar. You talked a little bit about the time from when
Judo asks if I've seen any new facts to justify impeachment.
I want to talk about that.
I don't know what you're referring to.
Would you
I'm
mind
judging
pulling
the
up
impeachment based on the
Article
evidence
6
submitted in this
of
trial,
The articles of
like I
impeachment?
always do. So I don't know what you mean by new. I'm judging the case based on its merits as being presented. So, yeah.
Article 6 accuses Mr. Paxton essentially of terminating or taking adverse personal action against employees for making a good faith report to law enforcement. Would you agree with that, Mr. Bangert?
It says he violated his duties of his office by terminating and taking adverse personnel action against employees of his office in violation of the state's whistleblower law.
Okay. So kind of what I just said, right?
I defer to the document.
Okay. Well,
Nice answer.
if we read from it, it talks about terminating or taking adverse personal action. So I would like to talk about what happened to you. Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Bangert. Were you fired or were you not fired?
I was constructively discharged.
No.
Good
I
answer.
asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively discharged.
Did Ken Paxton say you are no longer an employee of the Office of Attorney General?
He did not say that.
Okay, thank you. As a matter of fact, you resigned from the Office of Attorney General as the Deputy First Assistant Attorney General, did you not?
I did resign.
Okay, and you resigned under the title Deputy First Assistant Attorney General.
That was my title at the time I resigned.
Okay, so you were not demoted from your position as First Assistant Attorney General.
I did not lose my title.
Okay, and as a matter of fact, you were never suspended.
Good answer.
After you reported to the FBI, were you?
I was not.
Okay.
Very, very clever answer. Very, very clever
Mr.
questions, but doesn't do what he thinks.
I think
But
maybe
it
Webster,
doesn't go to where he wants it to
certainly Ken
be.
Paxton stripping you of some of your responsibilities, right?
Yes.
One of those responsibilities was the fact that you were in charge of the Special Litigation Division, true?
I was.
Now, that role was actually moved out from underneath you, correct?
That is correct.
And they put it in charge of the division chief that was running that division at the time, right?
My understanding was that Patrick Sweeten was put in charge of that division, yes.
So essentially, Brent Webster promoted an underlevel assistant attorney general? Yes or no?
I do not know if he promoted Patrick or not.
He certainly added some responsibility for Patrick, correct?
That was my impression, yes.
And that bothered you? Yes or no?
It came without explanation or warning, so yes, it was troubling to me.
Fair.
Possible that Mr. Webster just was promoting somebody that had been, I don't know, giving an exceptional performance at their job.
It's possible.
That was the excuse that he attempted to give me.
That's not what I asked you. I asked you if it was possible.
I don't think so.
Okay. Certainly they wouldn't take a job from Ryan Bangert, right?
That's not exactly what I said.
Okay. Sounded like it.
What a smarmy ass you are. This lawyer's such a
said that the
smarmy
environment-
jackass.
Did you describe it as being hostile after
He doesn't have it. He doesn't have the goods.
FBI?
He doesn't have the goods.
Yes,
Maybe
it was.
Toxic, right?
It was.
Affecting the ability for people to get their work done?
It was.
Okay. Now, you left and you went to work for the Alliance Defending Freedom, didn't you?
I did.
And in your time, well, that would have been.
He has tried to do
2020,
as
true?
best as he can with the nothing. And it is apparent that he has
The Office of
nothing.
Attorney General, and you went to Alliance Defending Freedom.
Counselor, can you?
Thank you, Nate the lawyer. Appreciate
back up a little
it.
bit closer
Sure.
to you. Okay.
Is that better, Judge?
That's much better for
Okay, I'm going to
all
lean
the
in here.
jurors.
Yes.
When you left the Office of Attorney General and went to Alliance Defending Freedom, that was in October, November of 2020.
November of 2020.
November of 2020. And since your time,
Yeah, I mean, he's zealously
all
advocating
the
for his
way up
clients.
until,
Sure, he
I
just doesn't
believe,
have anything.
2023.
It's all
isn't
all
it
show.
true You have brought cases from the Alliance Defending Freedom to be co-handled with the Office of Attorney General.
We have.
Okay. And some of those cases you have worked directly with Brent Webster, have you not?
There have been some, yes.
Specifically, State of Texas versus Xavier Becerra.
I believe that's the title of the case in Lubbock, Texas.
Okay. And that was one of a few cases, true?
Yes.
And all the while that you were bringing cases from Alliance Defending Freedom back to the Office of Attorney General, Brent Webster was acting as first assistant, true?
That is my understanding.
Okay.
Yes.
And Ken Paxton was acting as Attorney General.
Yes.
I'm not sure what that's supposed to prove, but okay.
I want to talk to you about the open records request, okay? You kind of gave us an explanation of how the process works, so I just want to rehash that out. My understanding is that if an individual makes a request to a state agency, that state agency has a certain time period to go to the Office of Attorney General and make a request for a ruling, right?
There is a statutory time period to request a ruling, yes.
Right. So in this case, the statutory time period, well, for example, when Nate Paul went to the Department of Public Services in March of 2020, if that was March 3rd, they had till March 13th essentially to request your office give an opinion. True?
I do not recall the specific dates, nor do I recall whether it was Nate Paul or one of his attorneys who made that request.
Okay. I just want to clarify, you do not recall the specific dates in which the DPS request by Nate Paul's attorney was made?
It was in the spring of 2020, but I don't recall the precise dates. I'd have to see some documents around that.
Eric, would you mind pulling up Article 3? And while we're doing that, just for a little background, Mr. Bangert, the requests by Nate Paul's attorneys for the records involved in the investigation, it was for initially the Texas State Securities Board, right?
Yes, the initial request went to SSB.
That was in 2019.
Is that a question?
Yeah, that was
Yes,
in 2019.
Yes, it was.
Then you've got DPS. That request was made in the spring of 2020.
That is correct.
And sometime later, arguably end of May, there was a request made for FBI's comment or brief on the DPS request that was originally filed in the spring, right?
I believe that was part of the second request.
Okay, so we're talking about 3 different records requests, correct?
I would classify it as 2 with a secondary request attached to the second.
Okay. And then you also have to throw in the request for reconsideration, right, on the Texas State Securities Board?
That was part of the first file.
So essentially, the Office of Attorney General makes 4 separate decisions about records relating to Nate Paul.
We made at least 3. I don't know if it was 4.
Okay. Well, let's go back to fall of 2019. Texas State Securities Board. At that time, was Ken Paxton the office of he was the AG of the Attorney General's office, right?
Yes, he was.
Now, when Nate Paul made that request through Aaron Borden, his attorney, in fall of 2019, that initial request was denied by the Office of Attorney General, was it not?
Yes, the ORD did, well, when you say denied, it sustained the request for exemptions and exceptions by the board.
Sure, meaning that the Texas State Securities Board, while Ken Paxton was AG, was not required to turn over records to Nate Paul.
That's right, the November request did not require turnover of records.
Let's move forward to 2020. you had a conversation with Justin Gordon about a request for reconsideration of the Texas State Security Board records, true?
I did.
And ultimately, you ended up having conversations with Ken Paxton about that request for reconsideration.
I did.
And ultimately, the Office of Attorney General again did not rule that the Texas State Board, the Texas State Securities Board was going to have to turn their records over to Nate Paul, did they?
We did not require them to turn their records over.
Okay. So up until, that puts us in February or March of 2020, would you agree?
We're ballpark in that area, yes.
Right, ballparking it because yesterday you stated it was right around the time COVID started.
Yes.
That's a whole nother convo we'll get into in a little bit.
That's that
Okay,
same
so
time
Texas
period.
State Securities Board records are not given to Nate Paul. Let's move on to DPS. Now, to be clear, the ultimate decision by the Office of Attorney General with regard to the DPS records was that they refused to rule in that situation.
It was a no decision.
Okay. Now, I want to talk to you about what that means. If the Office of Attorney General refuses to rule on a records request, that means that the state agency that was requested does not have to turn their records over to the individual, right?
We did not require disclosure based on that ruling.
Okay. And so, as a result of that ruling, the Department of Public Safety did not turn their records over to Nate Paul or his attorneys, true?
That ruling did not require disclosure.
Okay. Well, you're aware that there was a writ of mandamus filed by Nate Paul's attorney for those records they were trying to get from you, correct?
You're going to have to, the writ of mandamus, I believe, occurred with respect to the initial request. I don't recall one on the second request, but it may have happened.
You would agree there was a writ of mandamus filed?
At some point, it was my understanding that a writ had been filed.
Okay, and you're not going to tell this jury when that suit was resolved, are you?
No.
For a matter of fact, it could have been pending into the winter of the next year, true?
As far as I know, and for clarity, when you say writ of mandamus, I'm assuming you're talking about federal practice.
No, I'm talking
about circuit.
writ of mandamus in the district court for the Department of Public Safety records.
You're talking about the second issue then. Okay.
Yeah.
No, yeah, there was a pending action in the district court.
Okay, so they weren't just going to Office of Attorney General to try and get these records that they were after, right?
Could you repeat one more time?
They weren't just going to the Office of Attorney General, Nate Paul and his lawyers. They were also going to the district court to try and get the records they were after, correct?
That was my understanding.
Okay. Now, DPS was not required to disclose records after this refusal to rule, right?
Our refusal to rule did not require them to disclose.
Okay. Weak.
You stated that that was contrary to precedent at the Attorney General's office, true?
I did.
But you would have to admit that this specific request made by Nate Paul and his attorney Joe Larson had some unique circumstances, true?
I don't recall any unique circumstances.
Well, you worked with Justin Gordon pretty closely on this case, didn't you?
I worked with him very closely on the first file for SSB and somewhat, but less closely on the second file.
Okay. Could you kind of, so you really delegated it to Justin Gordon to handle, right?
No.
He was the man in charge of this decision, was he not?
He was the head of open records, answering to Ryan Vassar, the deputy for legal counsel at the time.
And he drafted opinions, and he drafted the opinion to refuse to rule that you edited, true?
I did edit the opinion.
Okay. Your Honor, may I approach the witness?
Yes, you may.
This is completely
Just don't
ineffective
talk on your
cross, in
way
my
up or
opinion.
back.
This is totally
Yes, Judge.
ineffective. I don't know what he's trying to get out of this witness, but it is some weak sauce.
I guess the point I'm getting at, Mr. Bangert, is that not every, like you said yesterday, you said that pretty much all of these requests are kind of the same. They're easy to rule on when it comes to law enforcement material, true?
They're not all easy, but we get a lot of them.
Right. You referenced the opinion, the law enforcement exception, true?
Yes, I believe that's correct.
That doesn't
When you say
necessarily...
the opinion, which one are you referring to, though? I want to make sure I'm answering accurately.
Well, the DPS opinion
I believe that's correct. I need to see it again.
and the FBI comment.
Again, I need to see the document.
To be clear, there was an initial request for DPS records in March of, or spring of 2020, true?
That is my understanding, yes.
Okay. There was a later, you're aware that DPS did not notify the FBI about the records, true?
I don't recall that. You'd have to refresh my memory on it.
So it sounds like you don't know every little detail about the records request, do you?
No, of course
No, and
it
that's
doesn't.
perfectly normal for a senior executive not to know every detail.
So yesterday when you said that the decision was not consistent with precedent, you didn't know every little fact about what was going on within this request.
Oh, please.
I knew enough to make that determination.
Please.
Did you, Mr. Bangert?
I am not omniscient, so no, I did not know everything, but I knew enough to make that determination.
Oh,
And it's
give
fair
me
that
a
maybe
break.
Mr. Gordon had a different opinion about what went on with regard to those records requests.
Mr. Gordon was working on that. I do not recall what his opinion was.
Okay.
Isn't it true you didn't know everything?
Are you aware that ultimately the Office of Attorney General did disclose the FBI comment?
I do not recall that.
Okay. Are you familiar with June Haddon?
June Haddon, the name is familiar. I believe she worked in the Open Records Division.
Okay. Would it surprise you to find out that she ruled that the FBI's brief on the DPS record should be disclosed to Nate Paul and his attorneys?
I'm not aware of that, but I'd have to see the ruling.
Okay. You hadn't heard her name with regard to this litigation or case today, have you?
No, not until today.
Okay. And you have no opinion as to whether Ken Paxton prodded June Haddon to turn those records over to Nate Paul, do you?
You'll have to ask the question again. It was coming fast.
There's no evidence, you don't know of any evidence, or you have no opinion that Ken Paxton told June Haddon to turn the FBI comment over.
I'm not aware of any conversation to that effect.
Weak. Lame.
Safe to say that in conclusion, every single request for records from Nate Paul's lawyers, none of those resulted in him getting the records with regard to DPS.
Yeah, Mark, you and I are looking at this
right?
very, very
I'm
differently.
not aware of any disclosures.
You and I
that
are
were
looking
made,
at this very, very
at least by our
differently.
office formally.
So essentially, every ruling that was made with regard to those records was the same, had the same effect as if you refused to require DPS or Texas State Securities boards to turn those records over.
The net result was they did not have to disclose the documents.
Okay.
This is a total
You were
cross-examination
involved with
fail for me.
bidding as well, right?
Yes.
Now, you talked about the fact that Ken Paxton directly ordered you to intervene into the lawsuit, true?
Yes.
Now, you would agree that if you thought something was illegal, you wouldn't want to delegate it to a lower level attorney, true?
That I don't even know how, no, that does not.
Yes or no? Would you delegate illegal activity to a lower ranking attorney?
The question doesn't make sense because I wouldn't carry out illegal activity.
Judge, I'd asked a non-responsive. I've asked him a question.
Answer the question.
Yes or no?
I would not instruct anyone to carry out illegal activity.
Right, that's why you didn't have Ryan Vassar sign that opinion in July of 2020.
I did not have him sign that opinion because I had a very bad feeling of where that was headed.
Okay. Well, let's talk about what you did in the Mitty case. You had no problem instructing, well, let me rephrase that. You did instruct Josh Godby to intervene into the Mitty case, did you not?
I did.
And when Ken Paxton asked you to file a motion to stay, you told the jury that you were opposed to filing that motion to stay, did you not?
I did.
But you turned around and you asked Joshua Godby to file a motion to stay in that case, did you not?
I don't recall that.
Okay. He filed a motion to stay, didn't he?
That is my understanding. Eventually, a motion to stay was filed.
Okay. You didn't walk up to Ken Paxton and say, Ken, I don't agree with what you're doing, and so I'm not going to do it.
I did not have that conversation with him, no.
And at no point did Ken Paxton say to you that if you do not intervene into the Mitty case, that you're going to be fired?
No, we never had that conversation.
You are aware that Mitty has been previously of interest to the Office of Attorney General, true?
You'll have to refresh my recollection.
Okay, well, when Greg Abbott was the Attorney General, you're aware that the Office of Attorney General filed suit against Mitty.
Yes, that did happen.
Okay, so you are aware that their background isn't necessarily squeaky clean?
I wouldn't put it that way.
Okay. You would not tell, you've got no knowledge that Ken Paxton was entering into the Mitty litigation for the purposes of benefiting Nate Paul, would you?
Well, I disagree with that.
Okay. Do you have personal knowledge? Yes or no?
I do.
You do?
Yes.
Well, Jeff Mateer made you aware of the fact that Jeff Mateer made you aware that World Class was disgruntled.
I'm not seeing Peter Stroke at all.
Performance in the intervention.
So I'm not sure what some of you guys are saying, but I'm not seeing it.
That was sometime later, but I received an email. I was copied on an email in which Jeff responded to current counsel for World Class, complaining about Joshua Godby.
Okay. So World Class was complaining about Joshua Godby, true?
They were.
Okay. Now, at some point, you stopped talking to Joshua Godby. I want to say that was, excuse me, let me back up. You stopped talking to Justin Gordon about the open records request, true?
At some point, the issue came to a rest,
Right,
so I would have no occasion to talk to him after.
Probably when you made the final ruling not to disclose the records in the Department of Public Safety request.
When the no decision was issued, yes, that's when it would have terminated.
Now, about 1 or 2 days after that, it might have been June 2nd, you started talking to Joshua Godby about the Mitty Foundation case, true?
That sounds about right, yes.
And Ryan Vassar has his hands in the open records request at that time too, true?
He was overseeing the open records division.
Because he took your position, right?
He did when I was promoted.
Okay. So Ryan Vassar is also probably
Some of you
aware
guys are
of
really having a
these
tough
different
time with this witness,
interactions
Peter
Nate
Stroke.
Paul, between the Office of Attorney General and Nate Paul, correct?
Man, I don't know.
To ask him that question.
Okay. Well, safe to say that he worked on the open records request with you, right?
He worked on it, yes.
And he worked on the foreclosure opinion with you, true?
He did.
Okay, so those are two different scenarios where you and him both worked on Nate Paul issues, true?
At least those two.
Okay, and it's fair to say that you and Mr. Vassar were discussing the fact that you both had been involved with Nate Paul.
I can see that me and some of the chat are disagreeing vehemently on this one.
These cases.
We had
That's all
discussion
right.
around those two instances. We discussed the work that we were doing.
Okay, so you would not tell our jury, the senators, that the executive level attorney generals did not know that different divisions or facets of the office were involved with or working on cases regarding Nate Paul, would you?
We began to piece together the linkages between these matters over time.
Okay. But you didn't do anything about it until September, I want to say 30th of 2020, true?
That's false.
Well, you didn't go to the FBI until September 30th of 2020?
We didn't go to the FBI.
Let's talk about that foreclosure guidance.
What's the point of
would
this
you mind
cross? There
pulling
is
up
no point. It's lame.
Article 2. And to be clear, Ken Paxton is allowed to intervene into a lawsuit if he thinks it's appropriate, true?
Our office has authority to intervene.
Okay. And he's in charge of the office, is he not?
He is the elected attorney general.
Okay. So if he wants to intervene in a lawsuit, he is allowed to do so.
He has authority to do so.
Okay. Looking at Article 2, it alleges that Mr. Paxton misused his power to issue written legal opinions under Subchapter C, Chapter 402 of the Texas Government Code. You're aware of this, right?
Yes, I see the article on my screen, yes.
Okay. Now, we actually looked at a copy of that exhibit. Eric, would you mind entering Exhibit 192, AG 192?
Yeah, Matt, you and I are roughly on the same page.
Exact copy of the House Board Manager exhibit that they've already published.
Yeah.
Would you scroll to the second page, Eric?
Yeah. Yeah, Adir, I agree, and I also
Mr.
agreed
Banger,
right off the
you talked about
bat,
that
where it's
very
like,
last paragraph.
didn't you say you haven't commented?
You actually
But isn't
signed
it
it,
true that you
right?
talked to the House? I'm like, you've got to be
Yes.
kidding me.
Okay. And by
You've
signing
gotta
it,
be
you
kidding
agree
me.
that you have adopted the statements within it, true?
Not necessarily.
Okay. So you just sign things at will?
No.
No? Okay. And you signed this document, right?
I did sign this
And
document.
the very last sentence or paragraph in that document says, it is not a formal opinion under subchapter C of chapter 402 of the Texas Government Code, true?
Would you scroll down to the last paragraph?
Well, you wrote the opinion and you read it a minute ago. You would
I'd
agree
like to
with
see
that.
the I would like to see the document.
I think I've got a copy.
You know, fair enough. Fair enough. He
there
wants
it
to
is.
see it.
You wrote, we trust this letter provides you with the advice you were seeking. Please note this letter is not a formal Attorney General opinion under section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance.
Yes.
You wrote that, right?
I did.
That was on this letter when you issued it in 2020, right?
It was.
Okay. So the very face of the document that you signed specifically states that it is not an opinion under 402, true?
No, that's not correct.
Specifically says it's not a formal Attorney General opinion under section 402.042 of the Texas Government Code.
It is not a formal Attorney General opinion
Okay.
under section 402. It's very different.
Okay.
Is it?
Let's talk about formal opinions. There's a specific place on the Attorney General website for a formal opinion, is there not?
Opinions that are issued are listed on our website, yes. They were assigned KP numbers and they are accessible by the public.
They are signed KP numbers. At this time, Judge, I would move to offer AG Exhibit 6 after I provide a copy to opposing counsel.
So far, the only bullshit I'm seeing is from the questioning lawyer.
If you have one more copy for us, we'd appreciate it.
I've got one more copy for the court.
I have no objection, John.
We'd still like to see it.
Yes, Judge.
Just so we can follow along. All right. Thank you, sir.
And we do appreciate everyone who expresses a different opinion, by the way, as long as they're expressed respectfully.
Eric, if you
which
would
so far
pause.
they have been.
And just stay on the first page.
We don't mind people that have a
So
different
up here in the
opinion, as
top
long as
left
everyone
corner,
treats
we've
everyone
got opinion
courteously.
number KP 0322. True?
Yes, it says opinion number KP 0322.
Okay. And that is an opinion number that is associated with a formal opinion.
I have not seen the rest of this document, but I'm assuming that this has the form and shape of an informal opinion.
Okay. Did you state yesterday during direct examination that Ken Paxton doesn't have a hand in signing or dealing with formal opinions?
I don't believe I said that, no.
Okay. So you would agree that he does pay attention to what he signs and what he issues on his office letterhead, correct?
He is required, or, well, I should say, he has a practice of signing formal opinions himself.
Okay. And that opinion has his name on it, true?
I cannot see it, but I would be welcome to look at the signature block.
Eric, would you flip back to the signature line? Okay. You see Ken Paxton's signature on that opinion, right?
Yes,
Okay. He has to sign these formal opinions, does he not?
I believe that is the practice of the office.
Unless he's been recused, in which event Jeff Mateer would sign the formal opinions, true?
That was the practice of the office.
Now, I want to talk to you about the opinions in this case. Originally, Ryan Vassar drafted the the informal guidance letter with regard to foreclosure sales, correct?
Yes, the informal opinion that was issued on August 1st, he did draft the initial draft, yes.
Now, The way that that record ruled, or excuse me, that letter ruled was essentially that you didn't attack the 10-person restriction from the executive order, right? You just said that judicial foreclosure sales were accepted from the rule and could go on with that restriction.
I would need to see the document to refresh my recollection on the precise contours of the opinion.
So almost 700 of you watching, by the way. Thank you very much for being here. I appreciate every one of you is here and joining us to be part of this. You are the reason this channel exists. Without you, there's not much point in it.
You drafted this opinion, did you not?
Well, Mr. Vassar drafted it, and I provided edits and corrections to it.
So you're familiar with the content?
I was 3 years ago.
Okay. Well, if you take a look at it, you would agree that it ruled that foreclosure sales could still go on despite the fact that there was an executive order restricting public gatherings outside to 10 people. True?
Please go to the next page.
I'd love to see if we could get to 1,000 people watching. I know we need 300 more people to have that happen, but that'd be cool. Just saying. Tell your friends.
There were very limited circumstances under which foreclosure sales could proceed, but we were subjecting those to the hard 10-person cap.
I mean, you testified with regard to the subject matter of this yesterday, didn't you?
I did.
So you would agree that you said that despite the fact that 10 people at max can gather in public, foreclosure sales can still occur, true?
That misrepresents the opinion.
Well, if there are, you said that foreclosure sales could still go on, did you not? Is that not what that opinion says?
No.
It doesn't seek to invalidate the 10-person rule, does it?
You need to go to the next page of the opinion.
Go to the next page, Eric. Thank you.
Is there a petition you can sign
The
to get me appointed to the Supreme Court? Well,
has operative language.
you can call 202-456-1111
Pardon me? Tell us about it.
and leave your opinion with the White House.
Sale is subject to and not exempted from the 10-person
So,
attendance limit
there's that.
imposed in Executive Order GA-28. It should not proceed if one or more willing bidders are unable to participate because of the attendance limit.
Okay. So, how are you saying that when Ken Paxton asks you to change the opinion, that it is contrary to precedent and the position of the Office of Attorney General at that time?
It made the ability to proceed with those types of sales more restrictive under the COVID limitations than our previous draft would have.
It made it more restrictive?
Yes.
Right, which means that, in a sense, it benefited people that maybe didn't have their jobs at the time and didn't have money to pay their mortgages off, true?
I do not know who this was benefiting. At least at the time I was writing it, I didn't know who it was benefiting.
Well, did you lose your job during COVID, Mr. Bangert?
Say again?
Did you lose your job during COVID?
I did not.
Did you struggle with the ability to pay a mortgage during COVID?
I did not.
You would have to agree with me that many people did lose their jobs during COVID, true?
I understand that that did happen.
Okay, and as a result of losing their jobs, many people probably couldn't afford rent and they couldn't afford their mortgage, right?
I also understand that financial institutions were suffering because of restrictions on their ability to foreclose on their loans.
Objection non-responsive.
May he please answer the question, Your Honor? Maybe let him be allowed to answer.
Is that an objection, or are you just making a comment?
It is objection.
It will overrule, but let him clearly answer the question, but answer the question directed.
Yes or no? My question was yes or no. Could that affect people and their ability to pay their mortgages and their rent?
Could what affect them?
A ruling that foreclosure sales, or excuse me, that COVID was in existence.
COVID was in existence at that time.
And it caused people not to have money and not to be able to afford rent and not to be able to pay their mortgages, true?
I believe the economic disruption caused by COVID had some of those effects.
Okay. And the job of the Office of Attorney General is in part to protect the public, true?
The Attorney General's office is a sacred trust, and it's always to be used for the public benefit.
Right. Now,
all of the public.
Eric, could you publish Exhibit 119 again?
What a lame question.
This is your memorandum of what happened with regard to the foreclosure opinion.
What a lame question.
And you stated in Exhibit 119 that you were not certain why Ken Paxton wanted this foreclosure opinion issued. True?
There's no exhibit on my screen.
119, Eric.
Maybe see it, please.
I think it's been entered, Rusty.
I said, we don't have it.
Oh, I understand. Eric's pulling it up.
This is Paxton's lawyer. It's Paxton's lawyer.
It's y'all's exhibit.
Is it in evidence? I don't think it's in evidence.
It's in evidence, Judge. I've already referenced it during this examination.
He submitted it earlier. You didn't object, I believe. Oh, I believe that's the case.
If that's
Yes,
the case.
no, this I
If
recognize.
that's the case for an error, but I don't think we had it marked as in evidence. Thank you very much.
Yes, sir.
You stated that you were uncertain why Ken wanted the foreclosure opinion issued. True?
He had provided me a rationale.
It's a yes
for,
or no. You said in this memorandum right here, you were uncertain.
I was uncertain.
Okay. Now, you did not include the fact that Ken Paxton was texting you all the while you were editing and drafting that report, did you?
I don't believe I mentioned text messages in this document, no.
And yesterday you told all the senators that it was contentious between you two on the phone at some points, did you not?
Oh, I don't recall saying that.
Okay. So it was calm and collected the entire time?
It was not calm and collected the entire time.
Okay. Well, you stated to them that you were objecting vehemently over the phone with Ken Paxton, true?
I did not say that.
You were objecting to Ken Paxton, were you not?
I was having conversations with him in which he was frantically telling me to make edits, corrections,
It's
and
a yes or no
ultimately
question.
changes.
It's a yes or no question, Mr. Bangert. You disagreed with Ken Paxton over the phone, true?
I had conversations with him about the contours of the opinion.
Okay, so you're not saying you disagree with him then, are you?
I was trying to understand what he wanted as his subordinate.
Okay. You didn't mention text messages yesterday, did you?
I did not.
All right. Eric, if you would flip to AG 1003 for me. Now, Mr. Bangert, you stated on direct examination yesterday that, quote unquote, Ken Paxton was acting like a man with a gun to his head. Did you not?
I did say that.
Okay. Now, looking at the last set of text messages here, if you'd flip to the last page, Eric. I'm just going to read from the exhibit. Thank you again. I can't express in words how much I appreciate your work, especially over the weekend. I am grateful because I feel like hundreds of people will be protected from harm and maybe devastation. You and Ryan deserve all the credit. Thank you. I hope that your Sunday is relaxing and enjoyable with your family. He texted that to you that day, didn't he?
12:19 on Sunday. Yes.
Okay. Now, did you mention that to the House Board of Managers when you were interviewed about this case?
I don't recall if I mentioned this text message.
Did you mention these text messages in your interviews with Mr. Harden or Mr. DeGuerin when you were preparing for testimony and trial?
I don't see why I would have.
Okay. And did you include it in your memorandum to Ryan Vassar that was produced?
There's no reason why I would have.
No reason to include a text message of him showing gratitude and why he wanted to have this foreclosure opinion worded the way he did?
I don't believe this was what he actually, I don't believe that he was telling the truth.
Well, there's
here.
certainly not a text message from you in these texts objecting or saying that you disagree with Mr. Paxton.
Lame.
I do not agree. I do not disagree with him here.
You don't disagree with him here.
I do not state it in writing here.
Okay. And you signed the opinion that was ultimately issued in this case, true?
I did sign it.
And that opinion has no binding effect.
It is a persuasive opinion.
Persuasive at best.
Persuasive opinion.
Okay. Did you tell the FBI about these documents?
I believe they were provided to the FBI.
Okay. We just didn't get a copy of them until today?
I did not have them in my possession.
Oh, okay.
They were in the possession of my counsel who found them.
Did you delete
recently.
your texts?
No.
So you would have had them on your phone, true?
No, I did not intentionally delete my texts.
Okay.
My texts are no longer.
Your texts were deleted, yes or no?
Gentlemen, don't talk over each other.
Your texts were deleted, yes or no?
I no longer have access
It's
to
a yes
texts.
or no question.
I no longer have access to texts past 1 year.
Okay. So in the year, you didn't think to take screenshots of these?
Excuse me?
You didn't think to screenshot these messages?
These were screenshotted back in 2020.
Okay. You just didn't keep a copy?
I did not.
It's so lame. It's so lame.
You're
These
not
questions
gonna
are
sit here and tell
lame.
us that you
This
know
cross-examination is lame.
that the foreclosure opinion ultimately
There's nothing
affected or
here
benefited
in this
Nepal, are you?
cross-examination. It does
I believe it did
nothing
affect and
to attack
benefit
the
him.
witness.
You have no personal knowledge of that, do you?
I have since learned that it did benefit him.
You wrote in that memorandum that you learned through the Austin Statesman, did you not?
May I see the memorandum again?
Eric, would you please pull up the memorandum? That's a newspaper, correct?
The Austin American Statesman?
Yep.
Yes.
Okay. So you got your information from a newspaper, did you not? If we're believing your memorandum.
If I could see my memorandum, I can tell you.
Oh, Eric, would you? 119, Eric. Thank you. I think it says on the following week, on August 4th, the Austin Business Journal, excuse me, I stand corrected. The Austin Business Journal reported that World Class had placed several properties into bankruptcy.
So it did.
That doesn't necessarily mean he learned it from there.
Are you aware of when the foreclosure was supposed to take place?
I was not aware of any foreclosures of Nate Paul properties when I was writing the opinion.
No, I'm talking about after. I'm talking about August 3rd and August 4th. Were you aware?
I subsequently learned that that was taking place.
That the foreclosure was supposed to take place on August 4th.
That I don't know for sure, but it would have been the statutorily appointed date, whatever that was, in 2020. And yes, now that I'm looking at my document, I do say August 4th, so that would have been the date.
Okay. May I approach the witness, Judge? Just to hand
Yes,
the
you may.
document. And Judge, at this time, I would offer AG Exhibit 295.
Any objection?
May I have just a second? I'm
Sure.
sorry, Judge. Thank you.
It's a strategic error in my view. Like, I don't necessarily mind that the skill of the
No
lawyer.
objection.
It's just an overall strategic error in my view.
Well,
Because
enter, what was the number on that? I don't have the number on that.
295, Judge.
there's not enough here to work
295 in
with.
evidence.
It probably would be better to let it sit
Would you mind publishing AG
than
295?
try to cross, because the cross is ineffective. So I think there's a strategic error in.
That is a letter from Sheena
doing the
Paul
cross at
to
this
the
point.
judge regarding the bankruptcy the foreclosure proceeding occurring the next day, dated August 3rd of 2020, correct?
He's doing his job well. I'm just not sure he should be
Executed
doing
by
it.
Brian Elliott.
Attorney for World Class, right?
I assume so because it has World Class's, one of their property names at the top of the letterhead.
You would agree that this document has the letterhead of August 3rd, right?
It is dated August 3rd.
Now, you were not present in the district court when this document was filed, were you?
No.
So you have no idea what impact it had on the district court judge in that proceeding, do you?
I have not talked or spoken with Judge Gamble about this, no.
Now, the very next day, the day that the foreclosures are supposed to occur, you find out that a bunch of Nate Paul properties are put, world-class properties are put into bankruptcy, right?
That's what the Business Journal reported.
Okay. You've been in civil practice for quite a long time, true?
Over a decade at that point.
You are very, very aware of what happens to properties when you file bankruptcy, are you not?
I was not a bankruptcy practitioner.
Well, surely you're aware that when you put a document, or you file bankruptcy on something, it causes a motion to stay, does it not?
There's an automatic stay that's applied based on my recollection.
There you go, which would prevent any type of foreclosure sale, would it not?
Again, I am not a certified bankruptcy practitioner. I know that there are exceptions to that. I can't even begin to speak to the legalities of these properties or how those would have applied in these cases.
Well, you knew a lot of law, on direct examination with Mr. Harden, and now you don't know about bankruptcy proceedings?
That's completely unfair. I know a lot of law too, and I don't necessarily know the particulars of every single provision. That's completely unfair.
The properties were going.
It's like, yes, I'm aware of automatic stay. I know that.
Sorry, they were going.
I'm aware that there's exceptions. I also know that. Do I know every single one off the top of my head? Nope.
It's possible that the bankruptcy filings did not, or those are what prevented the foreclosures. True?
I don't know.
Okay. Well,
but I think it's interesting that World Class submitted a copy of our
objection to non-responsive
opinion.
Objection to non-responsive. May I approach the witness, Judge?
Yes, you may.
It's like, it's like everything off the top of your head. No, I don't know everything, and I still learn things on this channel from time to time because I don't know everything. There's a lot of law out there. It's amazing. I try to keep well informed. I've got 2,500 videos on my channel. God knows I try to learn, but I don't know the finer points of every single provision of law. That's ridiculous. Fear No Stigma says, I think the difference on lawyers make the stand about the impropriety of the foreclosure without actually knowing it declared foreclosure. Well, strictly speaking, he's claiming the impropriety of the memo, not necessarily its ultimate effect in the real world, but your point's taken. His point is more about how the memo came to be in sort of the internal processes, not what effect the memo had in the outside world. He hasn't really been commenting about that as far as I have been listening.
I would like to offer AG exhibits that I've handed to both opposing counsel as well as Your Honor. I believe it's 262, 265, 275, and 283.
Hold on, slow down. 283, 275, 265, 262?
Yes.
I can shorten this a little bit. If he represents that these are their exhibit numbers that were originally agreed to, that we said we would not object to any of your exhibits.
Okay.
If they're covered by
yesterday I learned about statutory sale date at the courthouse in Texas.
Are they covered?
They are covered, Judge.
On stream.
Well, take that back. No, they're not. That's why I intend to offer.
I learned yesterday, right?
We have not
yesterday I learned. It's like, in Texas, when they do the sale, they do it at the courthouse steps on the first Tuesday. It's like, okay, I didn't know that yesterday.
No objection, Your Honor.
I know a lot of law, and I'm still learning things, Damn.
Can you just clarify for the record, we have one with a number and what the other numbers are? You may have the copies back.
So for purposes of the record, we're offering 262, 283, 275. I only gave you And then also 269.
No objection. 269 was a new number from the one you repeated back to me.
Yep.
Just want to be clear.
269, 275, 283, and 262.
I think I said 265. You repeated what I said. I was incorrect. It's 269.
Okay.
There's been no objection? I believe they said no objection. Mr. Harden, you said no objection, correct? Yeah.
Sorry, Judge.
Please enter those documents into the record,
Just going to okay. Thank you.
into evidence, excuse me.
May I approach the witness, Judge?
Yes, you may.
Guru for Hire says, whether Paul, apologize, you said, I think we learned Paul didn't benefit from the open records request. Even if that's true, it doesn't necessarily speak to
These are all bankruptcy filings by Nate Paul and his attorney.
It doesn't necessarily speak to the
August 4th,
propriety of the
August
Attorney
5th,
General's
okay?
office.
Say so.
You know?
Now, if these bankruptcy filings were filed on August 4th, the date that the foreclosures were supposed to occur, that would stay the foreclosure sale, would it not?
I don't know.
You don't know.
Perhaps.
So it's possible that Ken's issuance of the informal guidance letter didn't cause the foreclosure sales to go away. It's possible.
I do not know what effect that letter had
Okay.
on the foreclosure sales.
Yeah, fair enough.
Fan?
I'm sorry?
Are you a fan of Donald Trump?
I voted for President Trump.
Okay. You're a staunch conservative, are you not?
I am.
Are you aware that only a week after you guys issued this opinion, he issued an executive order that basically mimicked the attitude towards foreclosure sales?
I'm not familiar with that executive order.
Okay.
Which is completely irrelevant. Right? We talked about this, right? You can do a thing. The same thing can be legal or illegal depending on underlying other information. So did Trump do the exact same thing? Maybe. Does that mean that what Paxton did was legal?
Into
No.
the fall of 2020, right? August, September.
September is the beginning.
The conclusion doesn't follow.
And you didn't really have any contact with issues regarding Nate Paul from August of 2020 up until September.
Yeah, no problem, Mark in Texas. You're more than welcome to express your opinions as long as you're courteous about it.
You weren't working on the
That
foreclosure.
has long been the policy of the channel. As long as you don't,
I disagree with that.
as long as you don't devolve into insults as
was
to either me
completed
or
on
other
August
people in
1st.
chat,
You weren't working on
and
MIDI.
you're courteous, you're more than welcome to express an
Mr.
opinion.
McCarty had assumed responsibility for that.
You were not working on MIDI,
I was not working on MIDI at that time in August.
and you were not working on the open records request, true?
Those were finished.
Okay, so you were not personally working on any matters that involved Nate Paul at that time?
I was actively speaking with other members of the executive team about what was happening at that time, which was the desire to hire outside counsel.
So everybody, I assume, is on the 8th floor at this time, right?
We had COVID orders were still in place. I don't recall who was there every day. I was there every day the office was open.
And let's talk about that, because the OAG's position at that time was that everything should open up, was it not?
We wanted everything to be as open as possible, consistent with public safety and the governor's orders.
Even after you left the Office of Attorney General, your employees at the Office of Attorney General weren't even present.
There were some who were not present.
There were some. There were most of them that were not present.
My recollection was there were periods of time where large majorities of them were not working from the office.
Periods of time that postdated your employment at the Office of Attorney General.
I cannot speak to that
Because you weren't there.
because I was not there.
So that's not really inconsistent with the situation that was going on at the Office of Attorney General, was it? Yes or no?
That the attorneys were
Yes,
not
sir.
present,
Yes or no?
oh, that had nothing to do with our policy.
Okay.
Nothing.
So you were not personally a part of the hiring of Kamek, were you?
No.
You found this out on September 29th of 2020.
That he had been retained by the Attorney General directly?
No, that he was filing subpoenas with Michael Wynn.
Yes, I learned about that on the 29th.
And you're saying that that is the very point that it kind of stood out to you all what was going on, right? That was the tipping point.
That crystallized a number of things.
Okay. Now, when you say it crystallized a number of things, you did not have all the facts with regard to that investigation, did you?
I personally did not.
Okay. You didn't investigate that case, did you?
Was I? What do you mean by I wasn't investigating that case?
You didn't investigate the referral that was given by the Travis County District Attorney's Office, did you?
I was not the primary responsibility for that.
Everything that you took with regard to that investigation came from Mr. Penley or Mr.
I don't know
Maxwell.
why that comment, CG
No.
Dags, got me to laugh,
Those were
but
the
it
people
did.
responsible for investigating it. Were they
So
not?
congratulations on getting a smile out of me.
You
So
were not
that's nice.
responsible.
That was not part of my responsibility at that time.
Okay, so you weren't responsible. Now, despite that fact, you went to the FBI on September 30th, correct?
I did go to the FBI on September 30th, yes.
You went to the FBI.
Old school
without
Pizza
talking
Hut
to Ken
buffets
Paxton
were the
first,
best.
True?
They were awesome.
Oh, I talked to him many times prior to that.
You didn't talk to him about the fact that you were going to go to the FBI, did you?
We did not talk to him. We did not tell him we were going to the FBI immediately prior to going.
Right. So when you and Mr. Harden were talking about the conversations you had,
Who
with
used to
Ken
do
Paxton
book
about the
club
fact that you wanted
and
to
book
talk to
it in
them,
elementary
that was
school
all after
just to
you
get
had
pizza
already
at
gone
Pizza
and
Hut?
reported your boss to law enforcement.
I did.
True.
The text messages that we reviewed today
Read books
were
so I can
sent
get
after
pizza.
we made our good faith report.
It worked, man. They bribed me and it worked.
So you did not take the time to hear his side of
They
things.
tricked me into
before you went to
learning.
Law enforcement.
I disagree.
And at that point, you took it upon yourself to send a letter to Brandon Kamick as well, did you not?
If I can recall correctly, I was the one who did send the email containing Jeff's letter. Again, I'm stretching my memory, but I think I was the one who sent it.
Okay. Now, prior to doing that, you talked earlier about a set of text messages. I would ask to admit, to publish House Board Managers 225. Eric, would you? It's been admitted, Judge.
They tricked me into a lifetime of learning
I've gone a little
and
longer, a few
reading.
more minutes. Do you want to break?
And
now?
all I do is read.
I'm fine right now, Judge.
Is good for you now?
Yep.
Okay, we'll break for lunch now.
My work as a lawyer was
Can I raise
transactional.
one issue? I apologize, Your Honor. Can I raise one issue before we break for lunch?
Yes.
That may just help speed things along with this witness. You admonished Mr. Harden at the beginning of the day that if there were any statements that Mr. Bangert had provided that we haven't seen, that he was to turn them over to us. The witness has testified that there were actually 2 interviews that he gave to the House. We still don't have any information related to those. To the extent that there's work product mixed with that, I think they can redact that and provide us the statements. But I just request that we get those over the lunch break, and that may allow us to not have to recall the witness later.
Just continue to look during lunch break for those documents if you have those.
Thank you very
And
much.
if you do, turn those over by the end of lunch.
Sir, we do not have, but I'll continue to be sure. Thank you.
We will return at 1:10.
Yeah. Some people got the COVID vaccine for a free donut. Hey,
Either.
free donut.
That whole theory.
Was it Krispy Kreme? Because, Krispy Kreme's pretty good. I'm just saying. All right. So, yeah, at the risk of upsetting some of you guys in chat, this cross-examination does F all for me to attack this guy. It is so petty is the overall view of these questions. They're so petty and so banal, and I can't be bothered to care about any of these things. It's just it's scraping is what it feels, scraping the pan, scraping the bottom of the barrel, looking for any residue whatsoever. And yeah, you found a little residue as you scrape the bottom of the barrel. You found a little bit of jam left in the jar, but holy God, I don't care. It is not buttering my bread in this increasingly extended metaphor. So it's just not doing anything for me. So yeah, this guy comes off as completely credible. And he is, at least to my mind, answering the questions in a way I find completely responsible. The lawyer is desperately trying to pin him down to these gotcha yes or no questions. And the lawyer who's on the stand is not having it. Right? It's and he's answering the question in a completely honest way, in a way that avoids the gotcha. That it's I just want you to answer yes or no. No, how about none of those things? I'll answer it this way because it's smarter than your question, which that, by the way. There's no way that you didn't write the question to be that dumb. You knew exactly what you were trying to do because you're a smart guy, right? And you're just trying and no. And so I don't think that this has done anything to attack the witness's credibility. And so the points are so minor and so banal. It's like, did you know the finer points of bankruptcy? I can't say I did. No. Is it possible that it was the bankruptcy proceedings that prevented these mortgages from, or these sales from happening? Yeah, maybe, but that does nothing. That does nothing to attack the issue. The issue, of course, goes to the issuance, the creation and the issuance of the memo, not ultimately its effect in the world. Right? Just because if you try to do a criminal thing and like your criminal thing is not successful because of factors in the real world, it doesn't prevent what you did from not being criminal. Right? It's like, I don't know what a good analogy in this scenario is, but you know, you go rob a store, but they didn't have any inventory. So there was nothing to steal. Oh, okay, you know, no harm, no foul. That's not how that works. You certainly gave it the college try, and that's enough, especially if we're thinking about attempt, right? And like the fact that the results of your criminality were not as successful as it might have been designed to be does not prevent it from being criminal. So did his memo work? I don't know, nor do I particularly care. It doesn't really matter. What really matters is the purpose and design of the memo. What was the goal of the memo? What was it trying to do? Not necessarily what it did. What it did, if you want it this way, like what it did would go to damages, not liability, if you want to go that way, right? So if you go rob a store, how much you steal goes to damages. In a criminal context, it goes to how many years you're going to spend behind bars, because how much stuff did you steal? But that goes to damages, not liability. Like, it goes to your sentence, not whether you're guilty. Right? So your success or lack thereof might speak to the remedy, how many years you get or whatever, but doesn't speak to underlying liability, whether or not you're guilty or not. So, like, did the bankruptcy stay the thing? I literally don't care. Right? Was the memo completely pointless? I don't know, and I really don't care. You know, what matters is why Paxton did the things he did. Right? There could be legal reasons he did it, and there could be illegal reasons he did it. Like Paxton is saying in these text messages that he's doing it because he wants to help the people of Texas. Okay, if that's his motivation, then maybe. If his motivation is to help Paul and it just in an ancillary way also happens to help people, that's a much different thing. So his mental state is the issue. A lot of, the memo exists. What is his mental state for doing it? You know, he wanted to intervene in this charity thing. What is his mental state for doing that? What is his reason for doing it? Is he doing it because he thinks it's a charity that's corrupt and needs to be looked at? Even assuming, incidentally, that the Attorney General office has looked into that exact charity in the past. Wouldn't necessarily speak to this time. Because everything has to be looked at for its own reasons. So again, like if you do a legal thing, and then the next time you do the same thing, is it legal? I don't know. Maybe. Because why did you do it? Right? The same exact action. So even if the Attorney General's office has looked into this particular charity for fully legitimate reasons in the past, it doesn't mean this time was legitimate, because what matters is his motivation or the corruption of his motivation. So Daly says, unless he wrote a memo expressing his mental state, how are they going to prove mental state? Mental state is proven the same way that you always prove it, through action, through behavior. How do you prove mental state? The same way you always do. How was he behaving? How was he acting? What did he say? Is this normal? Is it abnormal? They've been proving mental state this entire time. Like, he was acting nervously. He acted like he had a gun to his head. or more the point, maybe they've been showing evidence of his mental state, maybe instead of proving. So I'll use slightly softer language. They've been showing evidence of his mental state. You know, he was acting nervous. He acted like he had a gun to his head. This is abnormal. You know, the attorney general wouldn't normally get involved this way. And it shows there's evidence of his mental state to be had. Yeah. Matthew says, I beg defense didn't anticipate getting much from the witness, so the junior was allowed to step in to get practice. It very well may be. But there's nothing here. And so I think maybe it's a strategic error, right? Because, you know, it might be a strategic error. Because if you cross-examine the witness and there's nothing there, then maybe you just reinforced the witness, right? So maybe sometimes the better thing to do is ask no questions. So it might be a strategic error. So that's worthy of consideration, whether it's a strategic error. Paxton acting like someone with a gun over the head was over the top. It should have been delved into. I think we all know what that means. It's an opinion a person could reach about somebody and the way they're acting. We all understand what that means, right? As a colloquial expression. So it's you know, and you see Paxton doing things like Paxton is having this meeting. Paxton is trying to convince you to do this. Paxton wants you to do this. Paxton wants to intervene directly in this charity thing. And like the entire staff, the entire senior staff is like, this doesn't make any sense. This doesn't make any sense. And you start seeing Paul's name behind all these things, right? You see the same guy's name behind all the things and you're like, corrupt motive. So the evidence, at least in my view, is heading in that direction. And this seems like overall a credible witness towards that end. I'd like to see more, but we're heading the right way. And like, you're really knowledgeable in the law. Do you know the finer points of bankruptcy when it relates to stays and the exceptions thereto? No, can't say I do. As a guy who also likes to think that he knows a lot about the law, I'm like, yeah, you got me. You got me. I don't know that one. I don't know the finer points of bankruptcy stays and their exceptions. You got me. I know how to look it up, but I don't know it off the top of my head. I guess I missed that one, you know? Yeah. Daly says, how's that prove his motivation was the Paul fellow? Well, I kind of already answered your question. So I don't know whether or not you're being genuine in your question or not. But the fact that Paul kept being a central figure in all these abnormal things is evidence that Paul is the motivation. Right? The act shows knowledge. Because you perform the act, it shows the knowledge there too. Black letter law. So the fact that Paul's name is the one that's constantly behind this stuff. Every time the Attorney General is acting really weird, Paul is somewhere in the background. Therefore, the motivation is Paul. Because he's the common factor, is a conclusion that one could draw. So the evidence is there. If you don't draw the conclusion at this point, I don't necessarily blame you. I'm not even saying that I draw the conclusion at this point. But the evidence is heading in that direction. I'd still like to hear more, but the cross-examination was ineffective. Yeah. How do you know what's truthful? The same way you know whether any witness is truthful, Rachel. You observe them, you listen to them, you try to assess their credibility. It's a question of fact. It's a question of fact, the same way you always do. I'll give you the standard instruction, or at least I'll paraphrase the standard instruction. You, the members of the jury, are the sole judges of the facts. It is up to you to decide what the facts are. In deciding that, you will listen to witnesses. It is up to you to judge the credibility of these witnesses. You can choose to believe these witnesses in whole or part. If you believe that they're lying about one thing, you can choose to believe other things that they're telling are truthful. On the other hand, you can choose to believe that they're lying about all things. It's also up to you to determine the weight of any particular witness. How much how important that person's testimony is a matter for you, the jury, to determine their weight. So it's a question of fact. Do you believe him? Do you not believe him? How important do you think his testimony is? How much does it convince you or not? How much does it tip the scales or not? It's a question of fact. And as one juror in this stream, I have given you my humble opinion. I find him to be credible. I find him to be believable. I find that he's telling the truth. The attempts to discredit him, I find to be banal and pointless and technical at best. You know, even assuming that he said, I never made a statement, which incidentally hasn't been proven, because they never showed that, by the way. So they never showed the contradiction. But even assuming that he said, I never made a statement, but he's talked to the House, that strikes me as such a technical thing, I can't be bothered to care. It's like, you've got to be kidding me. All right, yeah, I talked to the House impeachment managers. Yeah, it's like, yeah, okay. It's like, you know, it's just being so technically correct is the best kind of correct. It's looking for a contradiction when there's none to be found. Right? Because a person could say, I made no statements, meaning I made no statements in public. You know, I made no statements to the news. I made no statements in a general way. You know, but it's like, oh, didn't you do this? It's like, okay. It's like, it's just so, bleh. But that's what I think. That's what I think. So first of all, they didn't actually show the contradiction because they never proved that he said he made no statements. But even if they had proven it, I still wouldn't care. But that's me. That's me. I wouldn't care. And even if I did care, I still find the rest of his testimony credible because, again, as a juror, that's up to me. Right? So even if I did care and found it to be a lie somehow, I still wouldn't care because I can choose to say that's a lie and the rest of his testimony is still credible because that's something a juror can do. And that's my assessment of the thing. And I don't know what to tell you at that point. That's just how I see it. That's how this juror sees it in his humble opinion. You know? And so I think, you know, and also like even by the way, like as to the first witness that we saw, who was a lot more questionable in a lot of things, I still believed parts of his testimony. I didn't believe as much as I did with respect to this witness, but I didn't discount him completely. You know, I believe that he believes that he genuinely thought there was a problem. This is the first witness, the one that we made fun of for getting his soul sucked out of him. That guy, right? I believe that he believed that there was something rotten in the state of Denmark. I believe that he believes that he saw things that caused him genuine concern and troubles, and he saw things that he thought were abnormal with respect to Paul. How he then went about dealing with those beliefs, right? How he went about executing against that conclusion was questionable at best. But I believe that he believes that something was wrong. And you know, he's in a position to know because he observes the Attorney General on a regular basis. He observes the people in the staff on a regular basis. He knows, just as surely as you know, like from people you see every day, how do they tick? How do they act? You know, you go places and you interact with people on a frequent basis, I'm going to guess. You see some people on a fairly routine basis. How do they tick? How do they act? What's normal? What's abnormal? And so he was able to speak to that, and I found parts of that credible. You know, so you've got a witness who's at least credible in part, in my judgment, and a witness who's basically credible in full. And they're both kind of telling me the same thing. So, you know, it's like, well, I'm becoming inclined to believe it. I'm becoming inclined to believe it. I'd still like to ideally see more, you know, because you're asking, because also like, because the ask is fairly big, right? So the amount of evidence we need, at least to my mind, should somewhat meet the ask. Like, how much? What are you asking me to do? Right? So how much do I need is going to be directly related to how much are you asking of me. If you're not asking very much of me, how much I need to convince me is obviously not going to be very much. Right? But I mean, okay, this is a reasonably big ask. You're asking me to make a decision to throw out the duly elected AG. So, that's kind of important. And also, you're asking me to disqualify him from holding office again. That's kind of a big ask. I think we can agree on that much. So I'd ideally like a little bit more, but we are heading in that direction. The prosecution is, at this point, in the process of making their case. They're on their way. And, but for time considerations, which is a whole nother set of problems, it looks like they're going to get there, but we'll see. We'll see. They're both accomplished. They both have stellar educations. They both have lots of experiences in a lot of domains. Yeah. Okay. First, Last says, so were texts or evidence of his mental state beyond some people feels? I don't know what to tell you. His behavior and his actions can show his mental state. And a person's observation about a person's behavior is something a person can do. Surely there are people in your life that that you would be in a position to say, hey, you seem sad, or you seem angry, or you seem like you're off. Are there people in your life that you know well enough that you'd be able to determine if they're off or something seems amiss? I think so, probably. So these are those kinds of observations. He's probably not going to leave a text message that says, my nefarious plan is blah, 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 ha, 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 ha. So, you're not going to get that, but, you look to other things to do. Guru for Hire says, I think I'm going to need something more as to corrupt motive than speculation. Okay. Fair enough. Maybe we'll get more. But right about now, it's like the inferences are available. Okay, what time did they say that they're coming back from break? Because I'd like to, take a break. So, when do we come back from break? Does anyone happen to know? Because I wasn't paying attention because I was too busy talking to you guys. I was too busy talking to you lot. Ten after? Let's see. All right, so when do I want to schedule this stream for? All right, it's 1:45 right now. I got about 25 minutes. I'll schedule it for 5 minutes past. And we'll come back and we'll do this again. Opinions are in fact evidence. A person's observations about a person's behavior are in fact evidence. A person's observations about how another person's acting is in fact evidence. It's testimony. It is a kind of evidence, I assure you. The degree to which it convinces you or not is a whole nother set of problems, but it is evidence in the first instance. This reminds me of like a fight I had one time with someone about like testimony being evidence, because I was telling them something and they're like, what's your evidence? Because I was telling them about something that happened to me. Right? I was telling them about something that happened to me and they're like, what's your evidence? I'm like, the evidence is I'm telling you that it happened to me. So that's testimony, which is evidence. Yeah. So I was a first-hand witness, I'm telling you. There you go. There's your evidence. And good times. All right. I'm going to take a break. You can take a break. Well, actually, before I take the break, I need to wait for the Twitter to hit so that I can post the Twitter link and make you do my bidding, because you love me, and you will, because I know you will, because you love me. 36 seconds, is that the one? I think it is. Great. All right. So what I need you to do is I need you to retweet this many, many times. Hit all the retweets. And help me get some traffic for today. I would appreciate that. And go ahead and post the link in the new chat. Do that. Pin the chat. Great. All right. I will see you guys in about 25 minutes. Until then, I've been on Civil Law. I hope you've enjoyed this. I've enjoyed this. This has been very educational and exciting for all of us, I'm sure. And until then, I will be back. Till later. Bye.